Good morning, everyone. Welcome to the Maryland Public Service Commission's administrative meeting for January the 31st, 2018. I'd like to begin by recognizing the passing of former Chairman Frank Heinz. Chairman Heinz has had a long history with the state of Maryland, first serving elected to the House of Delegates in 1970. He served as executive director of the Employment Security Administration after that, and later became chairman of the Public Service Commission, where he served for 13 years from 1982 to 1995. Truly a Cal Ripken-esque record here at the commission. I think one of the greatest tributes to Chairman Heinz that I heard was from Calvin Timmerman, who said that Chairman Heinz trained staff to think of Marylanders not as ratepayers but as customers, and to treat them as customers. And by all accounts, Chairman Heinz was an extraordinary public servant, and our thoughts go out to his family at this time. One of the old-timers who knew Chairman Heinz at the commission is our own Commissioner Linton. So he looks young, but he's really an old-timer. And I'll ask Commissioner Linton if you'd like to say a few words.
Sure. Thank you, Mr. Chairman. I was, like many of you, saddened to hear of the passing of former Chairman Heinz. I worked with him at Baltimore Gas and Electric for 5 years as an attorney there, and I can tell you that he was always very accommodating, very willing to work on behalf of any citizens of the state of Maryland, specifically in BG service territory. He was one of the people who inspired me to continue to work on behalf of customers as often as I have, and I can certainly credit him as being one of the people that helped get me to where I am today. I also tell you that he was one of the fastest walkers I'd ever met. I mean, even at my young age, he would leave me panting as we went places. So I pray for his family and his friends, and for all of those who worked with him. You've had a good opportunity to work with a very special person. Thank you, Mr. Chairman.
Thank you, Commissioner Linton. Let's move to our minutes from the January 24th meeting. I'll ask Commissioner Richard if he'd like to approve the minutes.
Yes.
All right.
Second the motion. Are you moving the motion to?
No, since I wasn't here, I'll ask you to move.
Oh, I apologize. Yeah, I move that we approve the minutes.
All right. Is there a second?
Second.
All those in favor signify by saying aye. Minutes are approved. On to our administrative agenda.
Mr. Chairman, we have no consent agenda this morning, so item number 1 is Network Billing Systems, LLC, and CBeyond Communications, LLC, DBA Birch, filed a notification of transfer of ownership and new financing arrangements.
Good morning, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing that requests any required authorization for a transaction that involves the transfer of ownership interest in 3 Maryland telecommunications companies: CBeyond Communications, Network Billing Systems, I'll refer to them as NBS, and Birch Communications of Northeast, I'll refer to them as BCNE. The filing also notifies the Commission that NBS and CBeyond intend to participate in new financing arrangements. Through the proposed acquisition, the Birch companies, which include BCNE and CBeyond, and companies affiliated with Fusion Telecommunications International, I'll refer to them as FTI, intend to combine their business services. As a result of the acquisition, BCI Holdings, which is the Birch Company's holding company, will acquire majority interest in and control of the Fusion companies, including NBS. In an email to staff, the applicants explained that after they submitted their filing, they have modified the acquisition by providing for Lingo Management to directly acquire BCNE. Lingo Management is a direct subsidiary of Lingo Communications, which is another one of the Birch affiliates. Consequently, Lingo will become the indirect parent of BCNE. After the acquisition, the Birch shareholders will continue to be the direct owners of BCNE. In the filing, the applicants explain the proposed new liabilities, including new financing. The borrower under the new financing would be Fusion Telecommunications International, or one or more of Fusion's subsidiaries, which includes NBS and CBeyond. Also, the non-borrower entities, including NBS and CBeyond, will act as guarantors of the debt, and some or all of the new debt might be secured by the assets of FTI, including potentially the stock of NBS and CBeyond. In December, the applicants notified the Commission that they've increased the maximum loan amount from the $720 million to amount of $775 million. As explained by staff in its comments, the parties do not need commission authorization for the acquisition. The acquisition will enable the three Maryland communications companies to compete more effectively in the telecommunications market. Therefore, staff believes that the acquisition is in the public interest. The parties, though, do need authorization of the new liabilities, which includes the debt and acting as a guarantor. As explained in staff comments, the parties have demonstrated that the new liabilities are in the public interest. Therefore, staff recommends that the commission approve the new liabilities.
Thank you. Any questions for our staff? If not, do we have a motion?
Yes, Mr. Chairman, I move we note the transfer of indirect ownership of Network Billing Systems, LLC, CBeyond Communications, LLC, and the Birch Communications of the Northeast, Inc., LLC, and approve the new liabilities to be assumed by Network Billing Systems, LLC, and CBeyond Communications, LLC, including the new financing.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Next item on the agenda, item 2, is Level 3 Communications LLC, Broadwing Communications LLC, Global Crossing Telecommunications Inc., Global Local Services Inc., Level 3 Telecom Data Services LLC, Telcove Operations LLC, and Will Telecommunications LLC, all filed a notice of participation in financing arrangements.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This one's a telco refinancing. There's a filing by several companies, including 7 telecommunication companies in Maryland, that notifies the Commission of the company's participation in a new financing arrangement. Level 3 Parent LLC is the indirect parent of the 7 telecommunications companies. I'll refer to them as the licensees. Level 3 Financing has entered into a new financing agreement in the aggregate amount of $4.6 billion to refinance existing loans. The parties, including the licensees, plan to pledge their assets and to act as guarantors in support of this new loan. As explained by staff comments, the financing qualifies for the exemption from the need for commission approval. The parties have shown that this new financing will allow the Maryland telecommunication companies to compete more effectively in the telecommunications market. Therefore, we believe the financing is in the public interest. Consequently, staff recommends that the Commission note the financing.
Thank you. Any questions for staff? If not, do we have a motion?
Mr. Chairman, I move the commission note the financing arrangements for item 2.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Next item, item 3, is Astral Energy LLC, filed a notice of recent changes to the company's ownership structure.
Good morning, Chairman and Commissioners. Peter Wilson on behalf of the staff. Astral Energy LLC has made an informational filing notifying the Commission of the addition of a holding company to its corporate structure. Astral Energy Holding Company has been added as Astral's direct owner, with Jason K. Fox, Astral's former direct owner, retaining ultimate control as the 100% owner of the new holding company. Staff has discovered no complaints against Astral since the Commission granted its license in September 2017. In addition, staff has determined the company has no outstanding assessments. Accordingly, staff recommends the Commission note the filing as notice of the change to its corporate structure to include Astral Energy Holding Company, LLC, as direct owner.
Your questions for staff? If not, do we have a motion?
Mr. Chairman, I move we note the changes in ownership structure.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
The next item, item number 4, is Southern Maryland Electric Cooperative, filed revised tariff pages in compliance with order number 88515.
Good morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. SMECO's tariff, which is before you, embodies Commission Order Number 88515, which accepted in full a settlement among SMECO, the Office of People's Counsel, and staff. The settlement was reached after all parties filed full testimony addressing SMECO's request for a revision to its distribution rates. The new rates adjust SMECO's base rates to accommodate the removal of costs associated with SMECO's 230 kV transmission facilities from its distribution base rates. Consistent with the settlements, all classes, including solar facilities and transmission Naval Surface Warfare Center, which are not included in the cost of service study, receive a 6.12% decrease in distribution rates. The facilities charged for the facilities charge for classes General Service Non-Demand, General Service Demand, and Large Power increased 2.84%, and the Transmission and Transmission Naval Surface Warfare Center classes see a decrease in that rate from $939 to $900. The residential facilities charge is unchanged. The residential distribution energy charges decreases from 4.336 cents to 4.3 cents per kilowatt hour. The median residential customer consuming 1,106 kilowatt hours per month will experience a 3.74 decrease in his or her distribution bill. Staff has reviewed SMECO's filing and believes it is in full compliance with Commission Order Number 88515, and staff recommends the Commission accept the tariff effective with bills rendered on or after January 1, 2018, sorry. Well, we'd like it to go back to 2016, but we don't think we could actually pull that off.
Thank you, Ms. Garofalo. Any questions for staff on this item? If not, do we have a motion?
Yes, Mr. Chairman. I move that we accept the revised tariff pages for filing with an effective date of January 1st, 2018.
Is there a second? All those in favor signify by saying aye. Aye. Motion carries.
The next item on the agenda, item number 5, is Washington Gas Light Company filed a request for a waiver of COMAR 20.31.05.08C3 for the 2017-18 winter heating season.
So, the Utility Service Protection Program is governed by COMAR 20.31.05 and related orders. Its purpose is to offer low-income customers receiving Maryland Energy Assistance Program grants protection against termination during the winter heating season by lowering arrearages prior to the onset of the heating season, which runs from November 1 through March 31. Under COMAR 20.31.05.08C1, a first-time applicant for the USPP may apply all or part of the benefit associated with the MEEP to past arrearages after all other emergency funds for which the customer is eligible have been used. The purpose of applying the MEEP benefit to arrears is to enable the customer to qualify for the USPP, especially customers who are off service. However, under COMAR 20.31.05.08C3, this is a one-time election, and the customer may not use subsequent MEEP benefits to reduce arrearages. Under COMAR 20.31.01.01C, the Commission may modify a regulation under Subtitle 31 or grant a permanent or temporary waiver from any of the requirements of Subtitle 31 upon a showing of unreasonable hardship to a utility or a customer. The person affected by the requirements of Subtitle 31 must apply for the waiver. Washington Gas Light Company has requested that the Commission waive COMAR 20.31.05.08C3 for the 2017 to 2018 winter heating season on the basis that the prohibition against the use of MEEP benefits after the first year to reduce arrearages of low-income customers may create unreasonable hardship for those customers. WGL is applying for the waiver on behalf of its customers, and as a public service company serving these customers, WGL may be viewed as an affected person. If the waiver is granted, WGL will be able to apply MEEP funds directly to customer accounts with arrearages and to qualify the customers for USPP. A grant of this waiver may also help to forestall terminations during the winter. The Commission's USPP report shows that USPP participants generally have lower arrearages than similarly situated low-income customers who do not participate in the USPP. The USPP also offers participants the ability to participate in 12-month payment plans if necessary. Staff acknowledges that bill payment problems for customers in poverty present an ongoing issue, and although it is staff's position that the waiver of COMAR 20.31.05.08C3 promotes maximum participation in USPP, staff also believes that applying one's MEEP grant to a pre-season arrearage may be a two-edged sword. Reduction in the arrearage may allow participation in USPP, while the low-income customer's incentive to pay down bills may be lessened, and the value of the MEEP grant going forward may be eroded. This possibility notwithstanding, staff recommends the Commission grant the requested waiver for the 2017-2018 winter heating season for WGL.
Thank you, Ms. Garofalo. My only question is this coming, it seems to be coming a little bit late in the winter season. Is there a reason for that?
It was filed earlier than this. We did spend some time with WGL looking at the customers that it served and understanding their statistics. Ms. Suckling could give you more detail on that if you'd like, but that's why it's coming now, which is at best the middle of the heating season rather than in October.
Sure, if Ms. Suckling wouldn't mind if...
Morning, Chairman and Commissioners. Karen Suckling on behalf of staff. So typically when we receive a request for the waiver, we will look at the prior heating season, the average arrearage for those USPP customers. And when we looked at that, the data seemed different than some of the other companies for WGL. This led to multiple conference calls, data requests, and communication between staff and the company. And in the end of all that communication, WGL updated the data, and we were able to proceed with the comments and the filing. But that's why it took longer than the other companies.
Okay, thank you. Any questions for our staff?
Hey, just one quickly. Do we track I guess the customers that take advantage of this waiver request, and are there abuses that have been noted specifically? Okay.
We do track, though, maybe not each specific customer, but each year we do have a USPP annual report that is released that provides the data for different companies and these customers. I do not believe that includes any abuses by any customers.
Okay, so as far as these policy consequences or this double-edged sword, there's nothing really notable at this point that we should be aware of?
No.
Okay, thank you.
Okay, we also have Mr. Dodge here from the company.
Good morning, Chairman Hughes, Commissioners. John Dodge appearing on behalf of Washington Gas. Nothing to add, but happy to answer any questions you may have.
Thank you. Any questions? Yes.
Yes, good morning, Mr. Dodge. Just one question. Since we're discussing and considering the waiver today, which is obviously the middle of the heating season, how has the company interacted with and handled requests from consumers prior to today?
I think we've done our best to offer levelized payment arrangements and supplemental payment arrangements, but we've had to hold off on forwarding the MEEP grants pending the Commission's approval of the waiver.
Thank you.
Anything else? Okay, if not, I want to thank staff and Mr. Dodge. Do we have a motion?
Yes, Mr. Chairman, I move we grant the company a waiver of COMAR 2031-0508C3 for the 2017 through 2018 winter heating season.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
Next item, item 6, is Aggressive Energy LLC filed an application for a license to supply electricity or electric generation services in Maryland.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This item addresses a request by Aggressive Energy for authorization to act as an electricity supplier for commercial and industrial customers. Their management has significant experience in the energy industry. Their track record in other states has been satisfactory. The one concern that arose was in 2017, New Jersey initiated an enforcement action because Aggressive failed to apply to renew its license. New Jersey requires renewal of supplier licenses every 5 years. This was resolved, and it involved the company paying a $8,000 penalty to the Commission. Staff, of course, is concerned whenever an existing or prospective supplier fails to comply with regulatory requirements in Maryland or another state. However, in view of the company's prompt resolution of the license renewal issue and their overall satisfactory performance in the other states, we believe that the company is qualified to operate as a supplier in Maryland. We've reviewed their training and marketing materials and determined that they're satisfactory. Staff recommends that the Commission grant Aggressive a license to operate as a supplier in Maryland for CNI customers with the conditions recommended by staff.
Thank you. Any questions? Yes, Mr. Start with Commissioner O'Donnell.
Just very quickly, you said an $8,000 settlement with the New Jersey Board of Public Utilities. I think the paperwork says $7,500. I just wanted to clarify.
I was bumping it up. I'm sorry, Commissioner. I figured I just rounded out.
Clarifying for the record, I thought so. And since that settlement with the BPU, no problems.
Right, and we contacted all the commissions, and we asked them, you have any, do you have complaints, but more importantly, what's the track record? Are you concerned about these guys? And we received no feedback indicating concerns.
Very good. Thank you.
Okay, I think we all have a representative of the company here, so good morning.
Good morning, Mr. Chairman and Commissioners. Dan Messina from Aggressive Energy.
Thanks. Anything you'd like to add?
Not at this time, thank you.
All right, any questions for the company? All right, if not, thank you for coming this morning. Do we have a motion?
Mr. Chairman, I move the Commission grant the company a license to operate as an electricity supplier in Maryland for the customer classes and service territories applied for and recommended by staff, and to further direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries. Thank you.
Next item, item 7, is Utility Services Advisory Group filed an application for a license to supply electricity or electric generation services in Maryland.
Good morning again, Mr. Chairman and Commissioners. Kenneth Albert on behalf of staff. This item addresses a filing by USAG for authorization to operate as an electricity broker for commercial and industrial customers. There is a mistake in staff's comments. On page 2, we indicate that they're seeking authorization as an electricity supplier. Instead, they are seeking, just with respect for authorization as an electricity broker. In contrast to the Aggressive Energy case, which is kind of more typical of what we see, there may be, especially a supplier in many states, there may be some issues that have arisen. Typically, they've been resolved satisfactorily, and we recommend approval. Here we have what we believe is a much more serious concern. We're recommending rejection of this application because of fraud committed by USAG's president, John McDaniel, in connection with the telemarketing of mortgage modifications to services to homeowners by a company where he was an official, Washington Data Resources, which I'll refer to as WDR. Mr. McDaniel was an officer of WDR when the fraud occurred. The fraud stemmed from WDR telling consumers that WDR would arrange mortgage loan modifications that would lower the consumer's mortgage payments. In most instances, WDR charged the customers $2,000 for these services. However, in many instances, WDR was not able to arrange for a modification. In other instances, they did arrange a mortgage modification, but the modification did not reduce the customer's mortgage payment. And in some instances, the modification required the customer to actually make higher payments. The impact of this fraud was exacerbated by the $2,000 fee that the customer had to pay up front. These higher payments and the $2,000 fee likely made it harder for many consumers to continue paying their mortgages. The the Federal Trade Commission filed a complaint against WDR in federal court, and the FTC alleged that the company's actions violated the anti-fraud rules embedded in federal law. The complaint is attached to the application. A federal court agreed and issued an injunction that prevents Mr. McDaniel and other parties involved in the management of USAG from offering debt relief services or related financial services. The injunction went into effect in 2013 and is in effect for another 10 years, in other words, until 2023. Also, the court imposed a penalty of $2 million on Mr. McDaniel and the other defendants. Now, there are some mitigating factors here. In the 3 states where USAG is active, their performance has been satisfactory. They appear to have adopted procedures to minimize the risk of fraud, and they are seeking to serve only as a broker and only for commercial and industrial customers, and commercial and industrial customers are typically a fairly sophisticated class of customer. But what motivated staff here to take the unusual step of recommending rejection was the serious fraud that was involved and the fact that the injunction is still in place. Mr. McDaniel was the president, is the president of USAG, and we think that this would create too big a risk of fraud given the seriousness of this offense, which again threatened many homeowners in terms of the ability to continue to make their mortgage payment. I would note this is somewhat distinguishable because, of course, we just had an item, Aggressive Energy. There, it had to do with an offense failing to renew a license. It was promptly resolved with the Commission. There was no indication that consumers were hurt by this violation. We were also concerned by the fact that their website USAG's website stated that they were a supplier in the state. It actually said they have a screenshot that says Maryland's best business electricity prices. We contacted the company, and often the case we hear that because they have a small staff, they will update their websites only once or twice a year, and so they'll put in states where they're still pending applications. It's not something that should happen. They did remove it earlier today in response to staff's request. As of about an hour ago, they had removed it from the website, and we did confirm that. We did tell the company that we would be recommending denial of the application. We sent them a copy of our comments, and frankly, we urged them to come here today, and I don't think there is a representative from the company. Based on all this, again, the seriousness of the mortgage fraud, the continuation of the pending injunction against the company and Mr. McDaniel, we urge for rejection of their application to serve as a broker.
All right, thank you. Let's first take questions for staff. I'll start with Commissioner Herman, then Commissioner O'Donnell.
Thank you very much. Does USAG do anything other than provide brokerage services in any of these other states or anywhere? Is that their only business?
Alexander Speck for staff. The company itself does not, but officers of the company are involved with other companies. I have the list of those companies here. When you do call USAG's number, they answer, basically they're running 3 companies out of that same location. So whenever I call them, they answer as Churchill Downs. But as far as we know, that's all they do. Oh, what's that? Yeah, as far as we know, they just operate in those 3 states as electricity brokers.
Okay. And are you aware of any other issues related to this fraud from any of these other businesses?
No, these other businesses are clean, and the other officers that are associated with USAG have no prior background that worries the commission staff.
Okay. And are there any steps that USAG could take that would allay the staff's concerns? For example, you cited that there were steps in other states that have been taken to assure this kind of fraud doesn't occur in those states. If they were to take those kinds of steps, would staff potentially have a different recommendation?
They did give us the steps that they were taking to prevent any future fraud, but staff was not convinced by the steps that were taken. We were still worried about the history that their president was involved with the FTC violation, and we just didn't feel comfortable recommending that the commission approve the application, even though we did recognize that they did take steps to try to prevent this from happening again.
And what kind of steps were they?
They're listed in the buck sheet, but basically they, if they do have any kind of mailings, which hard copy mailings were the issue with the FTC violation and WDR, they will have an internal review and outside lawyers review that. Basically they're also saying that the suppliers that they do business with will get involved if they decide to send any hard copy mailings out to customers.
So an outside lawyer and the supplier they were doing business with would both review any mailing if a mailing were to occur?
That's correct, yes.
Right. And if they're not doing mailings, what else are they doing? Are they
They're telemarketing.
door-to-door?
They're telemarketing, they're calling by phone, and they are also advertising on their website and through other websites.
Okay. And there's been no issues with the telemarketing that you're aware of?
As far as we know, there have been no issues associated with USAG and telemarketing.
Uh-huh. And your comments note that Mr. McDaniel has no ownership or voting shares, but his wife does.
Correct.
And that to you is a concern?
Well, it basically just reinforces the staff's concern that he may have a fairly important role to play in the company, and he's president and director, and the fact that his wife has a almost 50% share of the company and he most likely has a very close relationship with his wife. Worries us a little bit.
And what about Caleb McDaniel? Is that a relative as well? Are you aware?
We weren't sure who Caleb McDaniel was, and we did not ask the company.
Thank you. Thank you very much.
Thank you. I have a few questions. The first one may be subsumed by our decision, but depending on what that decision is. But on page 3 of the application filed on April 21st, 2017, I believe, it says that they were applying for serving customers in residential, commercial, and industrial, all 3 categories. But the presentation says just commercial and industrial. Could you reconcile the difference for me?
Yes, there was another filing, mail log number 215090, where they did update the service territories and types of customers that they intend to serve, and they eliminated the residential class of customers from each of those territories.
Okay, fair enough. When was that made? Because I'm not seeing it.
This was filed on May 9th of 2017.
Okay, fair enough. Let me ask about the website, and I was glad to hear that that was fixed or corrected this morning, advertising operating as a supplier or broker in the state of Maryland. Did staff ask in their discussions with this company if they had actually consummated any contractual arrangements because of this advertisement, which lists a phone number, and had they actually done any business? Because if they had, it would have been outside the authorization and auspices of this commission.
Yeah, we did ask them about this, and they have not signed up any customers. And they did give us an explanation as to why they had basically advertised in a manner that we didn't approve of. And we were still not satisfied with the fact that they did end up having an advertisement in place that made it seem like they were qualified to do business in Maryland. But they have not signed up any customers as far as we know. We did ask, and there was no indication that they've done so.
Very good. Because, of course, if someone would do that, it would be a very significant thing if someone was operating outside of the requirements of the commission and the public utilities article. And lastly, let me ask this. Did staff consider how long this denial would live for? In other words, is this an indefinite, de facto indefinite denial, or is there a period with which reapplication would be given serious consideration? Help me understand the nature of the longevity of such a denial.
I think at the end of the day, they're free to apply again if they would like, but as of now, we don't feel comfortable with their record. Their record did not make us feel comfortable with giving them any kind of approval. But that decision would be up to the commission if they ever apply again for an application.
Okay. Sometimes, when we make a decision, we say without prejudice, or we say something to clarify that, and that's why I'm asking, just kind of, at least from my own understanding. So they could apply in the future, and we would just have to rely on our collective memories and record keeping to bring this back up should we deny it in our decision here today.
Yeah, my understanding is that you could do that, yes.
Very good. Thank you, Mr. Chairman. That's all the questions I have.
Sure. Any? Commissioner Rich?
I think most of my questions were pretty much covered, but I did want to just follow up on one that Commissioner O'Donnell just asked, and that is about, when you look at the various, remedies, either accept, deny, is there anything that we've done in the past along the lines of a probationary period or extra, scrutiny or review during a period of operations?
I'm not 100% sure, but I think Mr. Albert actually has some insight that he could offer.
Yes, Commissioner, occasionally, it's not frequent, but occasionally where there are concerns about a company, we have authorize them to operate on a provisional basis. In some instances, there's a reporting requirement. We'll say something like every 6 months, file a report on any complaints that have been filed with this commission or another commission by a customer and give a status on it. So we have done, it's not frequently done, but that has been used in instances where we feel there are some concerns about the company, but we're reluctant to just outright reject them.
Okay. And I truly applaud the staff for how thorough they look into these applications. But I did have a question about, as you look at the Public Utility Act 7-507, and you go through the list of, what needs to be done when assessing whether or not to recommend an application. Is there something specific that you have with regards to proposed company, or not, the applicant's management that is somewhat standardized, or something that we do apply across the board, or is it just a judgment that's made when you look at the application?
Yeah, I mean, on the financial side, financial integrity, we have a very specific objective scoring method, but flipping it over to where you have issues with performance in other states, it does get a bit more subjective. I know, for example, our transportation division has a very specific, their guidelines, which I guess now are part of COMAR, dealing with applicants for in their context. What do you do with certain violations? There's no analogy on our side in terms of the violations. And again, typically we're going to see companies that have been around for a while, have a lot of customers. There may be an enforcement action, in their past, and that has not necessarily led to a staff recommendation of denial. In fact, it typically doesn't. We'll note our concerns and indeed might suggest a conditional authorization. But it is more of a case-by-case situation. This was mortgage fraud that was fairly pervasive throughout the country at this time, and it did affect a lot of people, so it sort of struck a nerve there.
Okay, and that was a concern I had, that yes, in the late 2000s, there was the mortgage industry was kind of the wild, wild west, and there seems to is largely what brought the economy down at that time. So I was just interested to know, when we look at these applications and you scrutinize management, if we do have a standard, I guess we have a standard that we apply across the board to all applicants, right. Particularly in a case where you do have this management that is now in a different business than mortgages, and they are functioning adequately in other states. So I guess there's really not a huge question there, but it's just, I guess, a concern, and would be interested to know if we feel at this point we do have a standard that we are applying across the board. Right,
and I appreciate your concern. This did lead to a lot of discussion at staff, and frankly, the discussion always led with, gee, we usually don't recommend denial. It's usually the exception. There's conditional authorizations. There's the idea of maybe this is in the past, and we think right now they've been okay the last 4, 5, 6 years. So yeah, this did lead to quite a bit of discussion internally, and we just felt, given the seriousness of this violation and the continuation of this, the perpetrator of that as essentially the leader of the new company, that's what weighed heavily on us.
Okay, great. And I'm disappointed the company isn't here. I would have enjoyed the opportunity to engage, and maybe we might have come to, at least I would have possibly wanting to maybe push a little harder on a different outcome than the recommendation. But
yeah, we're disappointed too, candidly. Whenever we're raising concerns about an applicant's behavior, we're always saying, you're in a better position than us to explain if you think there's any circumstances that mitigate that in terms of our looking at you as a supplier and going forward. So we candidly let them know it was important for them to be here.
Great. Well, thank you.
Sure.
Any other questions?
Yeah, thank you, Mr. Chairman. Just one question. Do we know if at the time that WDR was accused of misrepresenting some of their products to customers, were they also engaged in offering any kind of energy product along with the financial products?
Okay, I've been advised at the time they were not involved in the energy business.
Okay. Just a secondary question. In the states where they were offering the products, they also had telemarketing prohibitions there as well, similar to Maryland. Do we know if those rules in those states were similar to the ones we have here? Have we had a chance to look at?
Well, no, I'm not familiar with the other states' telecommunication standards.
Okay, thank you.
Right, thank you, Mr. Speck, Mr. Albert. Appreciate your presentation. Okay, any discussion before we take a motion? Right.
Mr. Chairman, I would note that in the past, I believe we have denied without prejudice, and that would give the company the opportunity to come back and potentially agree to certain conditions that might make the staff more amenable to approving potentially on a provisional basis or that. So, for purposes of discussion, I would suggest that perhaps we deny it without prejudice.
And I would second that.
Any concerns about that? Okay.
Just a comment that that notion was really the embodiment of the question I asked about the length or longevity of such a denial, and I think that's okay. I just, for me, I wouldn't want to encourage personally, if I support this motion, that the company thinks that the decision of the staff originally was too harsh, because I don't feel that way. I will support this motion because I think, as the answer that we got from staff was, they could reapply at any time if they wanted to, so I'll support the motion, but I needed to say what my own feelings are on this.
All right, thank you. Why don't we take up the motion then?
Mr. Chairman, for item number 7, I move we deny without prejudice the company's license to operate as an electricity supplier in Maryland.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
The next item on the agenda is item number 8. It's Delmarva Power and Light Company filed a request for a waiver of CPCN requirement for replacement of existing wooden structures on Delmarva Power Circuit number 23002 with steel structures.
Peter Wilson again for staff. Public Utilities Article 7207 requires an electric company to obtain a CPCN prior to construction of an overhead transmission line designed to carry a voltage in excess of 69,000 volts. Delmarva Power and Light has requested a waiver of the CPCN requirement to replace 6 wooden structures with 6 steel structures on a 12.1 mile portion of Delmarva's 230 kilovolt circuit number 23002 in Wycomico County. The 6 wooden structures were installed in 1972, and 2 of them have been identified as in need of replacement by Delmarva's inspection process. Delmarva proposes to replace those and 4 other wooden towers with steel structures to bring the line into compliance with current PGM transmission line guidelines recommending anti-cascading steel dead-end structures at least every 5 miles. Public Utilities Article 7207 provides for a mandatory CPCN waiver for construction related to an existing overhead transmission line upon the finding by the Commission that construction does not require the company to obtain new property or right-of-ways through eminent domain or require larger or higher structures to accommodate increased voltage or larger conductors. Staff has investigated Delmarva's request, including documents submitted by Delmarva and its responses to staff's data requests, and concluded the work proposed by Delmarva meets the statute's criteria for a mandatory waiver. Accordingly, staff recommends the Commission grant the requested mandatory waiver of the requirement to obtain a CPCN for the proposed construction on circuit number 23002 in Wycomico County.
Thank you. Any questions for Commissioner O'Donnell?
Just a quick question for my own edification. What is a dead-end structure in regards to transmission lines? Help me understand.
Refer that to our engineer.
Okay, so we typically, Roger Austin for staff. So we typically have 2 types of transmission poles that accommodate our transmission lines. One would be called a suspension structure, which typically needs to be balanced by the lines on either side. So if there is if one side of the line were to go down, then a suspension structure may not be able to stay upright because of the extra force on the other side of that structure, and it may topple over and cause other structures to topple over. A dead-end structure is a self-supporting structure which can withstand the unbalanced force if one side, if lines on one side of that tower were to go down.
Okay, very good. I appreciate understanding that. I didn't know what that was. Thank you.
Thank you. Any other questions? All right, we have Mr. Seegers here from the company.
Good morning, Mr. Chairman and Commissioners. Matt Seegers, appearing for Delmarva Power. I have nothing to add to staff's presentation. Just here if you have any questions.
Any questions? Yes, Commissioner Herm.
Good morning, Mr. Seeger.
Good morning.
I just want to confirm that the conductor size is also staying the same.
That is my understanding. Yes, it is. It is,
Okay.
Commissioner.
Thank you very much.
You're welcome.
Commissioner
I just want to, I appreciate some of the illustrations that were provided in the application. As far as these steel structures, are they, they look like they are brown in tone, is that correct? And
I believe so, you're right. In our filing, we had some of the photos that you referenced. Those are generally what the structures will look like.
Okay, so those are that's the model you'll be using. So
Yeah.
for aesthetic reasons, it looks like they match somewhat what a wooden pole looks like. That was my impression. So I just wouldn't, as far as community impact or possible reaction from the area, from impacted people, that they would see these brown poles replaced, or the wooden poles.
My understanding, Commissioner, is that in rural areas, we do use it's called the weathered steel poles, which is the brown poles.
Okay.
In more metropolitan areas, we do use the steel poles, the actual poles that look like steel. So,
Okay, in this case, it looks like they would match the other poles that will be along this line. If those weathered steel poles are the ones that are being used.
I think that there will be a resemblance, Commissioner, yes.
Okay, great. Thank you.
Just a follow-up to that discussion,
Sure.
just to note, for the benefit of the commission, that in some areas of the state, these self-weatherizing poles have become somewhat unpopular in my experience, and were more popularly replaced in some installations by galvanized steel poles, which, to be honest with you, are more expensive for the installation, but are more aesthetically pleasing generally to the population. So that's just the experience that I've had with some installations in my former position as a state representative.
Oh, well, thank you, Commissioner O'Donnell. I was not aware of that. I was just going by the photos, and it looked like the weatherized poles closely resembled the poles that they were being replaced. So that's.
I tried to say that as delicately as possible, and there are people in the audience who will appreciate that.
Anything else? If not, do we have a motion?
Yes, Mr. Chairman, I move that we grant the company the requested waiver of the requirement to obtain a CPCN for this project pursuant to Public Utilities Article 7, Section 7-207B4I.
Is there a second? All those in favor signify by saying aye.
Aye.
Motion carries.
Thank you.
Next item on the agenda is item number 9. It's Baltimore Gas and Electric Company filed supplement number 612 to PSC Maryland E6. The company proposes to make revisions to the SOS administrative charges included in Rider 1 of its retail electric service tariff.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is a filing by Baltimore Gas and Electric Company to revise the time-of-use energy rates and to implement the February true-up of the Standard Offer Service administrative charge. The new rates are effective from February 1st until May 31st, 2018. Under the applicable SOS settlements and orders in case numbers 8908, 9064, 9056, and 9221. The costs of providing SOS above and beyond the actual cost of power are paid through the administrative charge. The components of the administrative charge were last established in Order Number 87891 in Case Number 9221, which among other things requires the company to collect the actual costs of cash working capital, incremental costs, and uncollectible components of the administrative charge, subject to true-up. The true-ups occur for BGE 3 times per year in February, June, and October. The return component of the administrative charge is only updated on an annual basis, and it is updated in this filing. As proposed, the rates would decrease a typical residential customer's bill by approximately 24 cents per month per 1,000 kilowatt hours. In addition, this filing includes updates to the shaped residential Type 1 and electric vehicle time of use rates, which were approved by the Commission in Order Number 88431 on October 20th, 2017. The time of use rates are shaped to adjust the pricing received in the SOS wholesale procurements to the load shapes for time of use customers, so as to retain sufficient incentives for customers to minimize their use during peak load hours. Staff has reviewed the filing and is satisfied that the rates are appropriately calculated. Staff recommends that the Commission accept for filing Baltimore Gas and Electric Company's revisions to residential Type 1 and electric vehicle supply rates effective June 1st, 2018, and accept the administrative charge rates in the retail electric service tariff and the revisions to the private area lighting rates with an effective date of February 1st, 2018. Also, OPC has filed a letter reiterating their ongoing objections with respect to the return component of the administrative charge, but beyond that, I'll let them speak to that issue if they choose.
All right, thank you, Mr. Spivak. Let's start with any questions for our staff. If not, why don't we do this first? We'll hear from the company, then we'll hear from OPC.
Good morning, Your Honor. Kim Curry, representing Baltimore Gas and Electric Company. Yesterday, we filed comments in response to OPC's request to reject our filing. I have nothing to add beyond that, but I am available for questions.
Thank you. Any questions for Ms. Curry? If not, thank you, Ms. Curry. Good morning.
Good morning, Mr. Chairman, Commissioners. Molly Knoll on behalf of the Maryland Office of People's Counsel. We did file a letter. Since that filing, we've also come up with another, what we believe to be inconsistency with Order 87891. I'll try to explain this as clearly as I possibly can. In the original December 15th filing, the relationship between the cash working capital component and the return component was 0.97 to 0.93, which was what we expected to see as far as taking the cash working capital revenue requirement, backing out short-term debt, and reaching the return component. While we disagree that that's what the language of 87891 would indicate, as we raised when this was initially brought before the Commission, and I understand Ms. Curry's concern that we're attempting to relitigate, when we brought up this concern, what the Commission wrote in the order and then the numbers that were provided, to our mind, appeared to be inconsistent. We brought that up on rehearing, as did staff, and is now on appeal. In line with that concern, in the second filing, the mid-January filing, the relationship between those two components has reversed. The cash working capital revenue requirement is now less than the return component, whereas the return component should be the cash working capital requirement minus the short-term debt. The company has explained to me why this is. In December of 2015, there was we couldn't possibly have expected or known what the tax implications of the new tax laws would be. So the cash working capital projection underlying the cash working capital revenue requirement closely matched the cash working capital number that was used to calculate the return component. Here's what's happened. The company is using a projection for the cash working capital component because that is trued up 3 times per year, every 4 months. Meanwhile, the return component is using a historical number that ended with October of 2017. When we had the case, I don't think anybody contemplated what a shift to cash working capital actuals would mean in terms of how we also calculate that return component. I don't think that's something that the order dealt with, and I don't think that's something that the parties have discussed. We discussed it a little bit this morning. We're willing to continue discussing how that should be calculated going into the future. But because the tax implications significantly reduced the cash working capital projection, that cash working capital revenue requirement is now 0.77. Meanwhile, the number for the return, which should be less than that cash working capital revenue requirement, is now more at 0.79 because it's using a historical number which included the previous tax rates. I don't have a good solution for that at this moment since I only fully understood it about an hour ago. But it is something that is going to continue coming up year after year after year based on how the Commission has ordered the setting of the administrative charge. In addition, it's not something that 87891 contemplated, and it's not something that 87891 dictated how to do. And when that return component is set on a yearly basis, what will basically happen is that the higher tax rate from 2017 will then dictate a higher return component for the company for all of 2018 until we reset it in 2019. In addition, as I stated before, we still consider this to be a double return on a single investment. The cash working capital revenue requirement at the overall rate of return compensates the company for the use of that money. And then the return component provides a second return on that exact same asset, which is precisely what Order 87891 said the Commission did not intend to do, that this was a regular utility service with a regular utility rate of return on that single asset. So those are our two concerns. One, we think this is not in compliance with the language of 87891, although the numbers matched up previously. Second, because we were dealing with a evidentiary case previously, we used the same number because we were dealing with a back record. Now that we've switched to actuals for cash working capital, we have a mismatch between the calculations of those two components, and that's an issue that simply didn't come up in 9221. I'm available if the Commission has any questions on that.
All right, thank you, Ms. Knoll. We'll start with Commissioner O'Donnell.
Just a quick question. So the issue that you raised with the Federal Tax Act and its implications on cash working capital in regards to this filing is not in the writings in the letter that OPC has submitted to us, correct?
Correct. We just flagged that yesterday afternoon, spoke with the company and staff this morning. We did, because the relationship between those two, my dad always told me when you do a math problem, just check for reasonability at the end. So as an attorney, I didn't check for anything more than a reasonable outcome in the December filing, and it had the same relationship we expected to see. On further consideration of the more recent, about 2 weeks ago filing, that relationship had reversed. And as soon as we realized that there was something going on, and the company explained that it's because the cash working capital is projected. Meanwhile, the return component is based on the previous year. So that's why that's the tax implications are why that relationship reversed.
And I imagine if OPC had time, they would be furiously working on another filing to explain what you just verbally explained to us in writing.
And I would have my accounting consultant working on it, as opposed to just me.
All right, I'll have a follow-up question for the company when they get up.
Okay. Anything else for OPC? All right. Thank you, Ms. Knoll.
Thank you.
Let's bring Ms. Curry back up.
Well, OPC, they state that the outcome was unexpected. However, they haven't pointed to any kind of violation of the Commission's order or anything like that. So the fact that the outcome is unexpected should not form a basis for rejecting this filing today. So that's one thing we would say to respond to OPC's comments. Also, to correct something that Ms. Knoll stated with regard to the prospective return. I'll let Mr. Frayne speak to you about that.
Good morning, Chairman and Commissioners. John Frayne from BGE. I just would like to clarify a little bit, a couple of things. One is that the filing that the company made, the amended filing the company made on January 12th to reflect the impacts of the Tax Cuts and Jobs Act on the SOS administrative charge, ensured that in 2018, the return component and the cash working capital component will be reflective of the new 21% corporate income tax rate going forward. So I don't want there to be any misunderstanding that, somehow the return component that we have proposed and filed for would reflect the corporate income tax rate from 2017, the 35%, and that the cash working capital component would reflect the 21% corporate income tax rate now ongoing. Both of those components both reflect the 21% corporate income tax rate now and will going forward. So I wanted to clarify that. The reason that, as OPC explained, that the relationship between the cash working capital component and the return component is different now is really based upon the fact that the cash working capital costs are based on a prospective forecast as well as a true up for whatever the actuals in the prior periods have reflected. The return component, the way that we are calculating it now, and the way that it was the calculations underlying the return component included in the Commission's order 87891 was based on actual cash working capital costs. So we are not including any forecasted amounts in the return component, and per the Commission's order, that return component would be subject to an annual adjustment going forward.
Just a follow-up question from the question I asked OPC. What is the timeliness requirement of this filing? In other words, what is the impact of time with regards to a decision on this particular filing?
Yeah, so the filing before the Commission right now is for rates to be effective February 1st, and so the decision made today will be immediately implemented in our billing system this afternoon and evening for bills to begin going out tomorrow.
So I have to make a decision today or else, or what could I defer this decision?
The implication of a deferral would be that the SOS administrative charge rates that are in effect, I guess, currently would remain in effect until until a further decision from the Commission.
So just speaking for myself, I'm not a fan of, like, for lack of a better picture for myself to draw, gun to the head decisions. So I'm not saying that we're there, but I'm not a fan of that, but I'm trying to figure out if we have the latitude to allow the record to be developed fully, considering what OPC has raised here this morning, considering this is a matter before the Court of Special Appeals in the state of Maryland and is going to get further entangled should we not take all opportunities to develop the record completely. So what I'm asking you is, does the company feel, in their opinion, that we have the latitude to allow that record to develop fully based on recently presented testimony?
I think that what the company could probably agree to is, if we allow the rates that we filed to go into effect now for February 1st, we could certainly take the time and maybe a short amount of time to talk with staff and with OPC about what we all believe may be the right way to approach this, and to come back to the Commission for an explanation of what maybe the options going forward, if there's anything different than the rates that that we have for you today.
Commissioner, if I might just briefly speak to that, I do note that with respect to the tax issues, at least, the Commission has ordered the utilities to be tracking the effects of those issues, and that mechanism can be used to address this issue as well.
I'm not sure what you mean by that can be used to address this issue as well. I'm not sure I understand that completely. So go ahead if you want to add a little bit more to what you said.
Well, what I'm getting at is that you have required the utilities to give regulatory asset/liability treatment and track all of the effects of the Tax Act on their revenues and expenses, essentially. In particular, the tax expense. So to the extent that this issue is grounded in the change in the tax law, that aspect of it should be tracked within the mechanisms that the Commission has already ordered for that.
Right. So I think that had we not had the presentation that OPC has just made verbally to us, that might make more sense to me. But I still would think we have a complicating factor here because of the issues raised and because of the litigation that OPC is engaged with in the courts right now on this specific matter.
On that point, I would note that although we do have OPC's appeal in the courts, the appeal does not actually stay the Commission's order. Generally speaking, court appeals don't stay Commission orders unless that is specifically ordered by the court.
Understood. So my question still becomes, and maybe staff wants to weigh in on this, do we have the latitude to delay a decision on this until we can get a further filing? Do we need to do that?
I think you have the latitude to do that. You have the right, for example, to suspend the filing and require further proceedings on it. I do note, however, that in this case, there, albeit modest, what's going into effect is a small rate decrease, and I don't know that we would want to delay that. So I would think from staff's perspective, BGE's suggestion that we allow the rates to go into effect, but continue talking about them and seeing if there's something further that needs to be done would be preferable.
Yeah, my concern is not the rate decrease now, but the impact on litigation down the road.
Why don't we, Commissioner Herman, then Commissioner Richard.
Oh.
Yep.
Mr. Frayne and Ms. Knoll, how long do you think, do you have a time frame? Are we talking a week, 2 weeks? What are we looking at?
I'll let Mr. Frayne speak to the time frame for doing the calculations. I would think a month would be more than sufficient. And I would urge the Commission to put these into effect because it is a rate decrease. I would state subject to refund if necessary. There was some debate as to whether or not that language was necessary at some previous administrative meetings. But we are certainly happy to engage in continuing discussion because I do think that this is going to be an ongoing issue that comes up again and again. And with a once yearly, the Commission would simply, I think, have to place into their decision that these were being, put into place expecting additional information and filings and allowing that there would be a kind of either a true up or a check on that return component in, maybe a month's time.
Well, Ms. Knoll, that's quite different than Mr. Field's letter to us, which is stating that BG&E's filing should be rejected and they should be instructed to refile their tariff. Now, are you saying it should not be rejected? We should go ahead and approve the tariff?
So if the Commission is persuaded by the argument as far as the double return is concerned, then yes, it should be rejected. If the Commission is not persuaded that we are granting a double return on a single asset, and we're simply looking at this relationship between the cash working capital revenue requirement and the cash working capital return component, accepting that we're going to be using the same asset to provide two returns, if the Commission accepts that premise, then they should accept this for filing, and we should have further discussions about how that should be effectuated moving forward.
Thank you.
Satisfies me.
Commissioner Richard.
So I just wanted to, again, I think ask along the same lines. So are we restricting ourselves at all, in future options if we go ahead and not delay implementing these new tariffs, giving the rate relief, but allow the Court of Appeals process to move forward, and we'll continue to require that the impacts of be tracked of the tax changes? Are we limiting ourselves in any way as far as future options? I mean, just going ahead and accepting the tariffs today and then seeing what comes out in the future.
So I believe it was staff's position that the rates are always subject to refund whether it's stated or not. So if the Court of Appeals decision comes out in OPC's favor, then there may be some requirement filing litigation decision from the Commission, anything along that spectrum, related to kind of truing up what would then be considered an overcollection by the company in that process. But I do agree with both the company and staff that we do need to have rates in effect in the interim. The Commission could look at this and state, while yes, we had specific numbers in 87891, and those numbers were implemented by the company a year ago, they could state that at this point, reading the order and understanding the language of the order, that this is, regular utility rate making with a return on an asset at the reasonable rate of return. The commission could make that decision now that the cash working capital revenue requirement and the return component constitute a double return and direct the company to refile tariffs in accordance with, that understanding of the order. If that's the direction to go, then I think they should be rejected and we should make that change quickly. If the commission is not intending to go in that direction and we are going to continue this, what OPC terms a double recovery, pending the outcome of the Court of Special Appeals decision, then I think we just need to resolve this question of what cash working capital do we use for calculating that return component. In that case, I would think we could fix that in about a month.
I guess just again, the very limited question. Saving that policy argument for another day.
Yes.
Okay, if we were to do that route and just let's move, we were to move forward with this tariff, which will provide ratepayer relief now. I mean, is there any thing that hampers us from having that full debate in the future if we go ahead and accept this tariff today?
So I think we would need to have the language that parties would be directed to refile on the return component in the near future. Otherwise, we're locked in for the year under 87891.
And do you think this is all going to be resolved through the appeals process and getting the data in a year, or is that a risk?
I think the question of what cash working capital we use and what short-term debt we use will not be resolved in 87891. It won't be resolved in that appeal process because that order didn't address those questions. I think that's something the parties can address and hopefully come back to the commission with something we agree on. But that particular mechanism, that was not, that wasn't worked out in that case. So the appeal won't address that.
I need to respond to something that Ms. Knoll just said. What she seems to have said is essentially that the commission could reverse its order on rehearing. And I think that doing that would be probably inadvisable, at least until the order on it, the court's appeal has come out. The commission heard the case on a number of times, in fact, and remanded it a couple of times. And as Ms. Knoll said, when the commission issued its order, ultimately, both staff and OPC sought a clarification regarding the return component, and the commission issued that clarification, and it would probably not be advisable from a procedural and due process standpoint to reverse that order on rehearing and pending the outcome, of course, of the case in the Court of Appeals.
Okay. All right. Thank you for that, and I think personally I'd be fine moving forward with this, and I don't think it ties our hands from taking up this issue down the road. So, anyway.
Okay, anything else? Ms. Curry.
Yes, I just wanted to echo what Mr. Spivak had said. You have already ruled on the double return issue. You did that a year ago on OPC's request for clarification. That was upheld by the Baltimore City Circuit Court. So, again, OPC said if you're persuaded today to change your mind, well, you've already made a decision on that point. With regard to making it subject to refund, we are okay. We are fine with having the rates go into effect today and continuing the discussion. And, we could talk with OPC about what type of methodology is sensible. It might be what we're currently doing today, but we're fine just having that discussion with OPC. But we would say not make it subject to refund. Whatever we decide, just be put into effect prospectively. Again, no one has pointed to anything to say that we're in violation of the commission's order. So for that reason, I would say we'll let these go into effect. We can go ahead and continue the discussions, and if we find something else works, then we can present that to you at a later time.
Thank you, Ms. Curry.
I just, one more question,
Oh, yeah,
if
sure.
that's all right. All right, so you said you wanted a month. Is that correct?
Yes,
Do you need a month?
I think we could certainly agree to come back to you sooner than a month if we're able to do that. I don't think the calculations would take a month, but I think we're allowing ourselves the time to have the discussions around those calculations and what's underlying them in order to ensure that we can come back to you with fully thought out answers.
Right, because my concern is if you take a month and then it takes a little while for a buck sheet and so on and so forth, and then we're moving on. So I'd like to get this resolved as quickly as possible. So could you do it in 2 weeks?
In terms of the calculations that we would have to do,
Could you
yes.
get back to the commission with a revised filing as a result of the discussions within 2 weeks?
We can certainly do that if that's what the commission would like, and we'll do everything we can to come back as soon as possible.
Okay, thank you. Mark, let's, before we take up a motion, let's put this up for discussion. So, I mean, I think I'm sensing from comments that we're all in agreement to go ahead and put these new lower rates in effect today. And also to take, I think, BG&E's offer to direct them to have a discussion with staff and OPC on the correct methodology and calculations for this. Now, if that's right, then I guess the question, when would we like them to report back? I think it sounds like it'll be pushing it, but they can do it in 2 weeks if that's what the commission wants. I'm not sure we're going to, what the result's going to be, but we want to make sure it's done thoroughly. Not
Right.
rushed.
I want to make sure it's done and done properly, but at the same time, because of the, once we get it, it takes a little bit more time for the staff to review it and get it on. So that's why I was trying to see if we could
Can I put in a bid for
resolve it
3
as quickly
weeks?
as possible.
May I put in a bid for 3 weeks?
Okay, 3 weeks would take us to February 21st. Commissioner O'Donnell?
I'm fine with that, Mr. Chairman. My understanding, based on this discussion, is if we accept these tariffs and approve the recommendations of staff, we will be consistent with previous orders and consistent with the matters before the Court of Appeals, and I'm fine with that. I think that's appropriate. And this other issue raised today, as staff suggests, can be taken care of in other forms, or if we decide to act on the filing, it's going to occur in 3 weeks. So I'm good with that.
Your Honors, if I may offer another possible solution, to make it not to exceed 4 weeks, just to give us some time once we get into the numbers and, if we find that more discussion's needed or something along those lines, it still puts a, cap or on getting it to you in 4 weeks. But we'll absolutely try to do something. If we could do it sooner than that, then we'll make every effort to do so.
All right. BG&E's offering to go back to a month. So how do we feel about that? Right. Commissioner Herman, this was your idea.
That's fine.
Okay.
No later than.
All right, no later than. All right, why don't I make the motion?
Okay.
I'll move to accept the tariff revisions to the residential Type 1 and electric vehicle supply rates for filing with an effective date of June 1st, 2018, and accept the administrative charge rates in the retail electric service tariff and the revisions to the private area lighting rates for filing with an effective date of February 1st, 2018, and direct the company to have discussions with staff and OPC on the correct methodology and calculation of these rates and report back to the Commission no later than February 28th.
Second.
There is a second. All in favor signify by saying aye.
Aye.
Motion carries. Thanks, everyone.
you,
We
Commissioner.
appreciate the discussion on this item. We're going to take one more item before we recess for about 10 minutes, so let's call item 10.
Item number 10 is Delmarva Power and Lake Company filed a request for approval regarding the Efficiency for Affordable Housing Program.
Good morning, Nick Garofalo for staff again. By this request, Delmarva proposes to use $2.9 million to create the Efficiency for Affordable Housing Program. This program will target multifamily dwellings within limited income areas of DPL's service territory and properties with rent restrictions that are located outside DPL's limited income areas, but inside its service territory. This targeting will be done using census and other data collected by the company. Measures and services offered under the proposal include building audits, an energy advisor, smart thermostats, LEDs, and upgrades to HVAC systems, hot water heaters, and refrigerators. The program is intended to bridge the gap between programs currently offered by DPL and DHCD's Multifamily Energy Efficiency and Housing Affordability Program. Delmarva is proposing this program in partial satisfaction of Exelon's merger commitment to provide Delmarva $11.7 million in funding for incremental energy-efficient program support in the Delmarva, Maryland service territory. DPL was further directed to use the funds to create pilots for innovative energy efficiency programs under Empower Maryland, with a minimum of 20% of the funds to be spent on energy-efficient upgrades in affordable multifamily dwellings. The targeted population and properties meet the requirements of the merger conditions in order number 86990. Participating property owners in DPL's program must agree not to increase rents for reasons related to the capital improvements made under the program for 3 years. Staff believes that this is the best option available to utilize the Exelon PHI merger funds for affordable multifamily housing. The company had previously proposed 2 different ways to use the remaining customer investment fund money. One proposal was to use the funds to offset the Empower surcharge, and the other proposal was to use the money to augment DHCD's existing MEHA program. Neither proposal was approved. DPL's design and forecasts for the proposed program appear to be in line with the intent of the customer investment funds and with the best practices from the Empower Maryland programs. Based on these factors, staff recommends the Commission approve Delmarva's Efficiency for Affordable Housing program.
Okay, thank you, Ms. Groffler. Why don't we first ask staff, you read OPC's letter and their concerns. Why don't you address, or I'd like you to respond to their concerns.
Yes. I'm going to ask Ms. Best to address that because she's very familiar with all of these programs.
Good morning. Amanda Best on behalf of staff. In terms of some of the concerns, I understand that there is a concern about overlapping with the existing Maryland Department of Housing and Community Development's multifamily limited income program. I think that the designs that DPL has proposed is different enough that it should hopefully prevent too much overlap between the 2 programs. Another way that I was kind of looking at DPL's design versus DHCD's existing MEHA program is that, the 300% of poverty level essentially gives you a broader range of customers, but it's still not going beyond people that are likely in need of affordable housing. I did some of the numbers on, examples of what 300% of, federal poverty level would look like, and for a family of 4, it'd be about $73,000, which is still below the median income for Maryland, which is around $78,900. And I think a useful way to look at this as well is there's often families that are kind of in between what you would consider, I guess, at the poverty level and what would be a median income level. And to that point, that to draw a parallel from existing Empower programs, you would have your home performance program for a family that could afford to make these weatherization changes on their own, while you would have the limited income program for families that could not afford to do it on their own. There's often families in between that don't meet those criteria that I think in this instance DPL's proposal could still meet and make significant contributions to reducing their energy load. I think that addresses some of their concerns. Mm-hmm.
All right, thank you. And, yes, Commissioner Richard.
Yeah, I just wanted to dig into this a little bit. I like the overall concept that there are gaps that would be filled by this program, but if I really understand what the OPC is saying is it's possible because of the way they're identifying the potential participants, it's a little broader than the requirements of DHCD, and so therefore you might grab people that would otherwise be okay to participate in the other programs, and then the problem would be that they would have measures, they would incorporate measures that didn't go as far as the DHCD programs, and that also these measures would potentially make them ineligible for any future participation in DHC programs. So OPC is here. I don't know if I've gotten that quite correctly, but while if there would be gaps, I would be concerned though that we would actually maybe be doing a disservice to participants if we were not careful to make sure they were in the right program. That's how I read the concerns of OPC. Do you want to respond to that, or maybe OPC can say I got it completely wrong?
You got it exactly right.
Okay.
Certainly. So I think that to address that concern, the way that DPL is going to be, categorizing eligible participants in this program, it is going to be different than DHCD. That's also just a function of what data is available to them. DHCD has a working relationship. It's part of OHEP's application that the company might not have the same access to those resources. So they're trying to use the best data available to them to categorize the needs of affordable housing in their territory. In terms of the measures offered, there is definitely some overlap. In terms of qualifying for those programs, I think some of a way I was looking at this is hopefully properties could potentially participate if they, in terms of some of the more costly measures like HVAC measures, that might not be something they do under MEHA because of the cost effectiveness, the overall cost of those measures. However, perhaps in a way they could go through MEHA first and perhaps then go and get some of those measures they weren't eligible to get through MEHA under this program. It's a way that they could complement each other and deliver deep savings.
Just going to the risk, it sounds like it is a significant potential risk and a disservice we might do if we did not carefully put or specify how this program should be, how it should move forward. Am I correct? Do you accept that notion that if they didn't go in that order, go to MEHA first, and then they could be made ineligible for getting the significant benefit of an HVAC system?
There could be a risk. You are correct.
Okay. Should that risk be taken care of first before we would okay this program?
There are ways that we could address it. Based on the design, I thought that risk would be minimal, but if the commission is concerned about that, there are further discussions that could be had to address those concerns.
Okay. Yeah, I would certainly not want to be someone just draw this out forever and ever, but again, based on I think what has been identified as an important item, important issue that needs to be addressed, perhaps that ought to be something we consider. Thank you, Mr. Chairman.
Sure. Commissioner Herman, then Commissioner Bell.
I have a question for the company.
Okay, well, anything for staff?
I have staff.
Commissioner
Bell. So I think last month we issued our final order and power order for the next 3-year program cycle, 2018 to 2021. And if memory serves me, the DPL surcharge increase for the first year of that new 3-year cycle this year was the largest in the state and was very significant. Does my memory serve me correctly on that?
If my memory serves me correctly, I believe you're correct. I can double check that, though.
Yeah. So subject to check, if it is the largest increase for the first year of the cycle, and there was an explanation for why that was. It was just the way the program cycle ran, and some programs that continued or didn't discontinue. And that order came out, well, first let me ask this. when was the decision made, or who made the decision that these funds couldn't be used to mitigate the surcharge impact on customers? I think Ms. Garofalo said it was rejected or denied. Who rejected that and when? Was it the company? Was it the commission?
I believe it was Order 88007.
Okay, so if it's an order of the commission, and then we have a subsequent rate impact on consumers based on our 3-year program cycle, couldn't we revisit that and appropriately order the use of these monies, or is there a reason we can't use these monies to mitigate the surcharge impact on DPL consumers, which is going to be very significant this year, if my memory serves me correctly?
Certainly. I think that there's nothing explicitly that would prohibit the commission from using this to offset surcharge funds. I think the one main concern is that the order of the language of the actual merger order was that this money was specifically to go to affordable multifamily housing. So I guess there would have to be some sort of way to ensure that those funds go to offsetting those properties. Some way of both of meeting that
Let me
condition.
interrupt here because
Sure.
I think Commissioner O'Donnell is asking really a legal question about the Commission's ability to change its order. So I think that's probably better addressed by Ms. Garofalo.
I'm not familiar with the precise order, but I think you certainly have the authority to consider. You probably would want to have some additional evidence before you, but you certainly would have the authority to make a different order.
But wouldn't the company have to agree to that? I mean, they agreed to our original order. If we were going to say we've changed our mind about this order and put new conditions in.
Well, I would, from a legal standpoint, I would say that the bigger problem, and perhaps this is, if I were more familiar with that order, it would be stated in there, but the Exelon merger order required that Exelon provide Delmarva a certain amount of funding for incremental energy efficiency program in its service territory, and I don't know that paying for existing Empower Maryland program would be deemed incremental, but that would be something you'd have to decide.
So it was, can I continue, Mr. Chairman? So there was a proposal to use this fund, use these monies to offset the surcharge. Who made that proposal?
I believe it was the company.
Okay, so the company had an interest in doing that? Or?
No. Can I speak
Yes,
to clear it up? So we had an initial proposal that we were going to supplement the MIHA program that DHCD wanted to do, and we had that, I think, in the last, not this most recent Empower order, but the order before that. And the commission denied that MIHA proposal, that where we would supplement for the MIHA. So that's why we came back for this proposal. And what the commission ordered us to do was take some portion of the funding that we had on the 20% 3C and reduce the surcharge as it related to multifamily residents. And so the commission ordered us to take some merger money from 3C and reduce the surcharge as it related to multifamily customers. So it wasn't a commission proposal. We had initially proposed to supplement the MIHA program, to give this to MIHA to prevent some of these issues that we're talking about today. That was denied. A certain amount of money went to lower the surcharge as the commission directed. And then we got another pot of money, and we met with NCLCA, the National Consumer, the National Housing Trust. We developed a new program where we weren't using MIHA money because when we had supplemented the MIHA program, it got rejected. So we thought, well, that's been rejected, so we have a new program, and that's where we are today.
And that reduction in the surcharge, that was, if my memory serves me correctly, that was related to an expansion of the MIHA program, not just reducing existing program budgets, correct?
That was my understanding, and that was a commission decision. We had not made that recommendation. As a matter of fact, we sought rehearing of that, and we were denied.
Right, and I think that expansion is why it did qualify under the conditions of the merger.
Yeah, we didn't appeal. We accepted that decision.
So let me then follow up with staff. What was the source of the major increase in the surcharge for DPL, if my memory serves me correctly, in our last order?
The source was the total program cost overall, so it wasn't tied specifically to multifamily housing.
Are you certain about that?
I can double check. I will certainly double check. But if my memory serves me correctly, it was total program cost, not specifically related to any multifamily program.
I'd like to know more about what the specifics of that large increase were, because, look, we do have a precedent of shifting some of these merger monies to mitigate surcharge. Company just said so, a small portion. Hang on, before you interrupt me, leave me finish. I want to finish my thought. Secondly, if we can find a way to minimize the impact on the Delmarva Peninsula on ratepayers, and there's a way to do so legally, I'd like to find out, or at least learn a little bit more about that. So I will then say, having said that, is there a reason we can't delay the decision on this matter to get the appropriate information to see if there's a way we can legally reduce the impact on customers, as the chairman alluded to and the commissioner alluded to earlier from our previous chairman, to limit the impact on customers in an economically depressed area of our state? Is there a reason we can't do that?
And all I was going to say is no, there's no reason that we can not do that. We're happy to do and look into whatever the commission directs us to do with respect to these funds. We had a merger condition 3C that we accepted, where the commission told us we had to take 20% of those funds for low-income multifamily housing, and we're trying to meet that merger condition. If the commission wants to meet it in a different way or give us a different direction on how we need to go, we will do that. Our goal is to meet our merger conditions, and by this filing, we thought we were doing that because the MEHA program was rejected, and we were told to go back to the drawing board. We went back to the drawing board with our partners, and that's what we did. We think this is a good program. We think it's going to be helping customers, but I certainly share and understand, Commissioner, your position with respect to the surcharge and customers. We care about that too.
I know you do. I appreciate the companies making this filing, and I appreciate your willingness to consider this further. All of the things that you described that occurred in our previous orders and previous rejections occurred prior to this last tranche of Empower surcharges that, to be honest with you, that particular one on DPL just shocked me, and I remember being shocked during our deliberations on that matter as to the impact on customers. So I appreciate the company's willingness to take another look at this, and I think the commission, Mr. Chairman, to be honest with you, ought to take the time to look at this further.
All right, well, we can discuss that. And let's get through questions first before we deliberate. All right, Commissioner.
Yeah, I just wanted to add to that I agree. I think I would like to have more information, because it was, thinking back to that order that we're talking about, where we denied the MEHA recommendation. I liked that recommendation, but it was my understanding at the time, the information we were getting, at least I got, is that it was not, it did not comply with the merger condition. And so if that is incorrect, if we do have more leeway, I would certainly like to know that before we decide where we go from here at this point. So I would support heartily Commissioner O'Donnell's suggestion that we maybe defer this item.
Why don't we do this, Ms. Knoll? I want to give you an opportunity if you want to make any other remarks based on your letter to do that.
No, Your Honor, I have nothing more based on the letter. I do have a slight input to Commissioner O'Donnell's suggestion. It's my recollection that the surcharges are peaking now based on more expensive years in the 2014 to 15 range. So using the merger 3C money to offset that, I think, would raise an intergenerational problem where we've provided a service previously and now we're offsetting costs and not providing an incremental service to current customers as required by 3C. But we would also be interested in relooking at the enhanced MIHA proposal. And I think that, as staff alluded, there are ways to take the current proposal and make it so that it doesn't directly compete with MIHA. 200 to 300% of poverty, include an SIR ratio. I just think there's a lot more discussions that could be had in this space on how to best use this money to, offset impacts on ratepayers and produce an incremental additional service for them.
All right, thank you, Ms. Nolan. Maybe this is a question for Ms. Best, but I mean, we've talked a lot about the MIHA program, and I'm looking in the audience. I don't see DHCD here. Have you had any conversations with DHCD? Have they raised any concerns about either overlap or potential conflicts with their program?
I didn't have any specific conversations with them. I'm not sure if the company did.
Oh, yes. All right. Thank you, Mr. McHugh.
So after the first rejection of the MIHA expansion program, we did speak with DHCD, and they were disappointed that that program was rejected, and they realized, at least we took it at Delmarva, and I think, I don't want to put words in DHCD's mouth, but they understood it as the commission didn't want the expansion of the MIHA program, and so they understood that. And then we met with, NCLC, National Consumers Law Center, National Housing Trust, to come up with this new program not using MIHA, because use of the MIHA had been rejected, and we even sought rehearing of that, and it was rejected. So that's why, going forward, we didn't talk to DHCD, because we had talked to them and formulated a program before that was rejected.
Well, and when I said talk, I wasn't mean selling them on the old idea. I meant
right. No, and we haven't heard anything from them where they have objections to this program, and certainly they were served with it, and I think they're aware, but I don't want to speak for them. But we didn't directly tell them we were filing this program.
Okay. Well, they're free to come here.
If I may, Your Honor, I have spoken with DHCD. I forwarded everything to them last week. I had a phone call with them earlier this week. They are working on their Empower filing, and that's why they weren't capable of being here today. They have their semi-annual report due this afternoon.
I have something for Ms. Noel.
Okay, and then
yes, Your Honor.
After that we'll go to Commissioner Herman.
So components of Empower for DPL going forward in the next program cycle will be for services provided prospectively, not expenses that were retroactive. Is that not right?
Yes, Your Honor.
So your argument that we couldn't use these monies to pay for retroactive expenses is maybe true, but there are still components expensing going forward for new services. Is that not so?
Correct, Your Honor, but offsetting the existing surcharge wouldn't be incremental to the approved plan. That's what the Commission decided previously.
Well, if we take a closer look at that, you may be right, but it's worth taking a look at if we're looking out for the interests of ratepayers.
Certainly.
Commissioner Herman. Anything, Commissioner Linton? All right, why don't we just have a discussion about this item first? I mean, I think from what I'm hearing from commissioners, I don't think we're ready, at least today, to accept staff's recommendation to approve it. But I'll just start the discussion by saying I certainly was ready to approve this item today. I think, and I want to. I think Mr. McKeel, maybe I'm sensing a little bit of frustration on his part. I want to state that I think PEPCO, that Delmarva, PHI, are trying to implement the Commission's order, in good faith, and I appreciate this additional proposal they've made. I mean, I think the reason the Commission rejected having these funds going to MIHA is because we had absolutely no confidence that DHCD at that time could get this money out the door and get it to customers, so it would benefit customers. And so that was our reservation. We're throwing more money at them when they couldn't get their existing funds spent. And I think it's still a concern. I think it's important to note that when the Commission approved this, the merger, which included a settlement, that as part of that was with the National Consumer Law Center. I mean, this was a very important part of their settlement, which they agreed to. And we have a letter from them supporting this program. So, I certainly would be concerned about the Commission changing directions and not using these funds for the purpose for which this settlement was approved, which is to put additional resources into multifamily housing in the Delmarva service territory. With that, we can take this under advisement. I'm happy to do that if we want to discuss it more. But if I had my preference, I would approve this today. So I'll turn it over to whoever else wants to speak.
I want to make a comment too.
Yeah,
Commissioner.
I would like to suggest we do take it under advisement. There were a couple questions. I was actually prepared also to just go ahead and approve this today, but pending outcome of questions about OPC's concerns. After hearing those concerns, I do now have reservations as to how quickly we should move forward with the proposed program until we get some answer from DHCD and make sure that these gaps, that are truly being filled, and if there are risks, that we try to mitigate those risks or educate potential participants the best we can. So I think on the program itself, I think it needs to be developed a little more. I'm also very concerned about rate impacts, particularly as we go into this next cycle. So I would like to have a more definitive answer as to could we use these funds also potentially for the existing programs, MIHA programs, rather than necessarily creating a brand new program. I agree it must be compliant with the merger condition, and it does serve the intended recipients. But if we could get a twofer, that is, provide the funds and get the necessary public served with these funds, with existing programs, without additional administrative charges and all those other types of things that go into creating a new program, I think that would also be a good option for us to consider. So I would also just advocate for deferring this item and taking it under advisement.
Okay, Commissioner Linton.
Sure. I actually was not as concerned about the possible mixing of programs between MIHA and the new program DPL is proposing, particularly on staff's presentation on page 4. The new program was looking to only cover 125 participating units. I mean, there's clearly a need that extends beyond that. But if we can find a way to make the program more efficient and work more effectively for those consumers that need it, then I'm certainly in favor of that as well. So I have no concern about taking some more time to make sure we get it correct.
All right. We'll go down this way. Commissioner O'Donnell.
Thank you, Mr. Chairman. I did not come into this particular item predisposed and ready to approve it, but I also did not come into this particular item predisposed and ready to disapprove it. I wanted to ask some questions about it and explore some items. The sentence that jumped out at me from the buck sheet was this: the company had previously proposed 2 different ways to use the remaining customer investment fund money. One proposal was to use the funds to offset the Empower surcharge, and the other proposal was to use the money to augment DHCD's existing MIHA program. Both proposals were denied. I didn't know what that meant coming in. Now it's clarified for me, and I know. But I think that all of that occurred prior to significant changes made to the next cycle of the Empower program, specifically for DPL and its surcharge impact on the ratepayers in that service territory. In the end, if we take the time, we defer this and take the time to explore these items, I think that's appropriate as long as it doesn't cause a negative impact. I feel since it does not. I think that would be appropriate. In the end, it may be correct that we need to approve this. In the end, it may be that we explore other ideas. In the end, maybe we find a unique way to give some rate relief to customers who are going to be disproportionately impacted compared to other utilities for the Empower program on their surcharge in this first year of the new cycle. And if that's a possibility, I'd like to take the time to do that. I think that's reasonable and prudent, and therefore I strongly support the notion of deferring this until we can take a closer look at it and maybe sharpen our pencils.
Okay. Anything, Commissioner?
Oh, I'm not opposed to taking it under advisement, Mr. Chairman.
Okay, yeah,
Uh,
Ms.
yes.
Garofalo.
Your Honor, is there something that you want to help you in your, there's been a lot of questions, some of them were not completely answered, that would help you, or do you want to just take it under advisement in your usual fashion?
Right, I'm not sure if we have anything today, but as part of that, if we feel like we need some additional information, I think we could make that request. So, Miss, our Executive Secretary, can we take this under advisement without needing to suspend anything?
I don't believe there's anything to suspend here today, Mr. Chairman. If you do take it under advisement.
All right, why don't we do that? Appreciate everyone's discussion of this item. We will take it under advisement. Before we recess, I'd like to introduce a new employee at the Maryland Public Service Commission. I'll ask Ms. Casey Brent to please stand. I want to welcome Ms. Casey Brent to the Commission as the new Director of the Office of External Relations, who is replacing our own Commissioner Linton, who had that in his formal role. She is now with us today. I believe is her first day. Ms. Brent brings a wealth of experience to the Commission. Her most recent positions in Baltimore City government in the Mayor's Office of Economic and Neighborhood Development, and as a policy and legislative advocate, as well as an interim Deputy Director of Parks and Recreation. Ms. Brent has a bachelor's degree at Mary Baldwin College and a master's degree at the University of Maryland. Ms. Brent, on behalf of the Commission, welcome. We look forward to working with you. All right, thanks. We are going to take about a 10-minute break. We'll be back actually around 12:10, and we will take our last two items up. Okay, if I could ask everyone to take your seats, we'll get started. Great. Mr. Collins.
Okay, next item on the agenda is item number 11. It's Baltimore Gas and Electric Company filed Supplement 613 to MDE 6 and Supplement 443 to MDG 9. The company proposes to reduce base distribution rates to flow the benefits of recent tax legislation to customers.
Good afternoon, Mr. Chairman, Commissioners. Lloyd Spivak again for the Commission staff. This is a filing by the Baltimore Gas and Electric Company intended to reduce distribution rates to flow benefits of the recent tax cut legislation through to electric and gas customers. At the outset, staff notes that the Commission has issued an order directing all utilities to make a filing to explain and track the impact of the tax cuts, but staff also notes that BGE took a proactive stance on the issue and brought their proposal before the Commission voluntarily. Staff does appreciate that action on BGE's part. On December 22nd, 2017, President Trump signed H.R. 1 comprehensive tax reform legislation enrolled as the Tax Cuts and Jobs Act of 2017. For our purposes, the most significant aspect of the reform calls for a reduction in the statutory federal income tax rate from 35% to 21%, effective January 1st, 2018. On January 5th, 2018, BGE filed electric and gas tariff supplements designed to flow tax savings associated with the Tax Cuts and Jobs Act to ratepayers. In total, BGE requested authority to distribute $81.7 million to electric and gas ratepayers to account for the reduction of the federal income tax rate. On January 11th, 2018, BGE amended its filing for the purpose of grossing up the calculated tax savings to ensure the revenue requirement, the basis for the revised rates, reflects the collection of income taxes at the new 21% statutory federal income tax rate. The amended filing is intended to distribute $103 million in tax savings, of which $72 million is electric and $31 million gas, to ratepayers. In the filing, revenue requirements were modified to flow savings related to the change in the federal statutory income tax rate, and also to incorporate changes necessary to refund excess accumulated deferred income taxes. Under BGE's proposal, an average residential electric ratepayer using 925 kilowatt hours per month should expect to see a reduction in their monthly bill of $2.91 per month, and an average residential gas ratepayer using 57 therms per month should expect to see a reduction in their monthly bill of $2.94 per month. A dual service electric and gas residential customer should expect to see a reduction of $5.41 per month in their monthly bill. BGE has requested that the Commission waive the 30-day notice requirement of Public Utilities Article Section 4-203 to allow for the implementation of tariff pages detailing the revised rates with an effective date of February 1st, 2018. Staff reviewed the filing and believes that the refunds are reasonable. Most aspects of the rates were generally calculated in an appropriate manner, except for the electricity customer charges and private lighting schedule rates. BGE's proposal did not modify customer charges because, according to BGE's response to a staff data request, doing so would require a cost of service study, and the customer charges approved in Case 9406 are below the values supported by that case's cost of service study. BGE's proposal also does not reduce the rates for the private lighting rate class. When asked, BGE indicated that this was because the private lighting class had not received any increases in Case 9406, even though two other rate classes that also received no increases in that case will have their rates reduced under BGE's plan. BGE added that private lighting customers will receive benefits because they also tend to take service under other rates, and that the allocation method used here was also used when BGE eliminated its nuclear decommissioning charges. Staff believes it would be inequitable to leave the private lighting class out of the current rate reduction, and that in light of the Commission's policies favoring more customer control over energy bills, it is also appropriate to allocate a reasonable portion of this tax reduction to the customer charge. Accordingly, staff has put forth a modified version of BGE's proposal, and this modified allocation is what we recommend the Commission direct the company to implement. In addition, staff noted that in a rate case, taxes are allocated on an income basis rather than a revenue basis. We therefore prepared for the Commission's consideration an alternative allocation proposal which allocates the tax reduction on a class income basis. However, since we are not flowing through the tax decrease in the context of a rate case, this is not our proposed recommendation at this time. OPC has filed a letter opposing staff's proposals and offering their recommendations to the Commissions. I will let them explain that. Staff notes that most of those recommendations have already been addressed in the Commission's order establishing Case 9473. However, we would like to express our disagreement with OPC's request that the Commission require BGE to file a rate case by July 1st, 2018. First, although the final accounting for the tax changes should occur in a rate case, so long as the regulatory liability BGE establishes has an appropriate return component, there is no need to be in a particular hurry to have that case. Second, staff is mindful of the logistical difficulty of having too many rate cases proceeding simultaneously, and until we know better what procedures will be necessary to address the tax reduction flow-throughs by other utilities, we would prefer not to add that extra proceedings to the Commission's calendar. BGE also filed a letter responding to staff's proposal and indicated that they prefer their proposed allocations over staff's modified proposal. Again, I will let them speak further to that. Staff continues to believe that our proposal is more equitable and more in keeping with overarching Commission policy. Staff has its recommendations set forth in staff's comments. However, I did just have some brief discussion with BGE before this presentation, and they clarified something with Mr. Valcarengi, and therefore on item 3 of staff's recommendation, there will be a modification. So please listen closely when we get to that point. Staff recommends that the Commission, 1, waive the 30-day notice requirement of Public Utilities Article Section 4-203 to allow implementation of rates effective February 1st, 2018. 2, authorize BGE to implement rates consistent with the revenue requirements as proposed by BGE in its January 11th, 2018 filing. 3, direct BGE to establish a regulatory liability to account for tax savings for January 2018 for changes in operating income, and the remainder of that item in staff's buck sheet should be deleted.
When you say let me interrupt you there. When you say the remainder, you're talking about the excess at
Correct,
ADIT
Mr. Chairman.
with the inclusion of a return component?
Correct, Mr. Chairman.
Is that with the inclusion of the return component? Are you recommending that stay in, or that take that?
I think actually the inclusion of the return component should stay in there. So it's simply deleting the reference to the excess ADIT.
Okay.
Okay. 4, except for filing, the proposed gas rates is filed by BGE with an effective date of February 1st, 2018. And 5, direct BGE to file clean electric tariff pages based on rates as proposed by staff with an effective date of February 1st, 2018.
Okay, thank you, Mr. Spivak. Why don't we do this? We'll take questions for staff, but they're not going anywhere, so we can always come back with them. We'll hear from OPC, and then we'll hear from BG and E. So let's with staff, so thank you, Mr. Spivak. I want to try to understand better staff's view on why it is relevant to consider what happened in the last rate case, because staff, am I correct in that staff believes that we should, I'm trying to find it here, not only should there be no return for, hold on a second, for PL, but there also should be no return for T and SL because both of those classes did not receive a rate increase in the last rate case. Is that correct?
I think actually that's kind of the reverse of what we did, because we wanted the return on the tax for all three, whereas BGE left out the private lighting class. And as far as the on a broader level, the relevance of the last rate case is the outcome of that rate case, and the revenue requirement from that rate case is what underlies BGE's proposal in its entirety. They needed a starting point for how to calculate and implement this tax reduction, and that provided that starting point. So, and you also, I referred to it in my comments earlier, when we asked for the explanation of why the private lighting class was left out. BGE's explanation went back to the outcome of the last rate case and the fact, and the same was true with the customer charges. So really, one of the reasons BGE could do what it did here was because they had a relatively recent rate case, and that certainly makes it easier to figure out how to flow through a change such as this in a time period between rate cases.
Okay. Let me ask you about the proposal to have some of the savings go to the customer charge portion of the bill, and to reduce the customer charge portion of the bill. Should we consider whether or not the customer charge was increased in the last rate case, or is staff recommending that a reduction be kind of proportional to the overall amount of the total bill that the customer charge represents?
I think I'm going to be getting in over my head on this, so I'm going to ask Mr. Hoppick to stand by very quickly. But my understanding is that the customer charges were increased some in the last rate case, and that was one of the bases for us thinking that it would probably be appropriate to reverse that. I mean, bear in mind that in large part what this is going to do, what this whole proposal is going to do, is essentially reverse the increases that occurred in the last rate case. And so we thought it was appropriate to distribute the reductions in the same way that the increases were distributed. And that's probably as much as I want to say without further help from Mr. Hoppick.
All right, well, Mr. Hoppick, why don't we bring you up? Because I had a follow-up question. That is, if we're going to have a uniform approach, and our approach is, well, some of this money should go back in the customer charge, shouldn't we also apply that to the BG&E gas side and in our next item for the WGL customer charge?
So good afternoon, Mr. Chairman and Commissioners. So I'm going to briefly turn to Jennifer Ward on the why there's no changes in customer charges for gas.
Good morning, Chairman and Commissioners. Jennifer Ward, on behalf of staff. The reason that gases didn't change and wouldn't for, I'm speaking ahead, but for WGL is we followed the same. If there was an increase in the customer charge, we were decreasing it proportionally. But for the gas in WGL and BG's gas, there was no increase in the customer charge, so that doesn't apply.
All right, so staff's approach is not that some of this money should go back to the customer charge because the customer charge makes up part of the bill. It's what kind of happened in the last rate case. Would that be?
Yes.
All right, I guess I'm still struggling with why we should put such relevance in what happened in the last rate case. What, in terms of, I mean, did staff think about the impact on the next rate case? I know we have OPC's recommendation that we have rate cases filed in July. I think it's clear we're going to have some rate cases coming in this year and perhaps early next year. I don't know, when BG&E might come back. But if we accept the staff's recommendation, this is for Mr. Hoppick, are we going to be in a position where we're going to actually lower customer charges temporarily and then have to increase them again, in a year from now? And would it be better policy just to account for the fact that the customer charge was not lowered in the next rate case, as opposed to having to go down and right back up again?
So ultimately, what you would decide in the next rate case would, of course, be up to you. So, we again, as Jennifer Ward mentioned, we wanted to be consistent with how revenue was allocated within the class in the last rate case. I would also note that if you also only reduce the distribution energy charge, the ratios of how much money you get from the fixed customer charge to the distribution energy charge, that will change, and that is generally part of the decision on how to raise the customer charge relative to increases in a distribution charge.
All right, thank you. Let me turn it over. I've asked enough questions for now. Let me turn it over to we'll go with Commissioner Herman, and then I'll look this way.
Good afternoon. So just to be clear, you're not arguing with the $103 million, you're arguing with the allocation of the $103 million, is that correct?
That is correct.
Okay. And OPC, I believe, states, and I might not get the numbers exactly right, but that your allocation methodology results in residential customers getting about 30% of the reduction, and BGE's results in around 50% of the reduction. Did I get that right?
So not entirely. So our recommended reduction includes the private lighting class. So under BG's method, I can look up the number right now. Under BG's method, the residential class gets 51.8% because we're proposing in our recommended allocation to also include the private lighting class, which is a relatively small class. That would drop to 51%. So there, it would go from 51.8% of the 72 million to 51% of the 72 million.
So not a significant number.
I think the numbers that you were referring to, Commissioner, actually refer to the alternative proposal that staff prepared that was based on class incomes rather than revenue.
Oh,
correct.
And you're not recommending that alternative?
That's correct.
You're not recommending it, but you provided it?
We provided it because the income, the revenue requirement, how to put it this way. The basis for allocating a revenue requirement in a cost of service study in a rate case is class incomes as opposed to class revenues. And if you follow that logic through, then you would be allocating this decrease in the same way according to class incomes. And there are some possible reasons for wanting to do that, including consistency with rate case methodology. So we thought we wanted to present that to the Commission as an option that you could consider. We did try and discuss in our comments what the ramifications of doing that would be, and ultimately we decided not to make that our recommendation, but that, strictly speaking, might be the most correct way of doing it.
So, may I add? So, in addition, we believe that if you allocate based on current distribution revenue, we think it is likely that for the electricity classes for BG&E, that the classes that are under-earning will become more under-earning going into the next rate case, and the classes that are over-earning will become more over-earning going into the next rate case, such that it becomes more of a challenge how you then apportion revenue across classes assuming there's some sort of increase, with the goal of attempting to get classes closer to a uniform rate of return, of course, accounting for gradualism as the commission always does in the one-step, two-step process. So in many ways, it's recognizing that we think this will create more pressure on that question in the next rate case.
I would also have to note that there is. Sorry. I'd also have to note there is some contrary reasoning as well, because ultimately, when the commission allocates an increase in the rate case, they may or may not rely on what's done in the cost of service study, and that's the origin of doing it by incomes. So what actually shows up at the end of a rate case is a revenue requirement, and that's ultimately how the rates are calculated. So there are reasons for doing it either way. In this case, we chose what we thought was the preferred option for this instance.
Thank you.
Who's next? Commissioner O'Donnell, then we'll go.
So this filing, and I commend the company, this filing was, I think, the first filing we got on this. Came in January 5th and was amended January 11th, and then we issued our order on January 12th. How does staff view this filing as meeting the reporting requirements contained in our order 88530 issued on the 12th of January?
I think you mean in terms of tracking the as regulatory liability and the further impacts. BGE has done a pretty good job of explaining the impacts and how they should flow through in its rates. As specified, they will be tracking anything that's still missing, and that will be taken into account when they do file a rate case. The third element is that BGE remains bound by the Commission's order that was issued on January 12th. To the extent that there are other reporting requirements in there, they still have to meet those requirements.
So the report required to be filed on or before February 15th still needs to be forthcoming, explaining the impact of the TCJA on the company's expenses and revenues and how they expect to pass through those to the consumers.
You might want to clarify that point, actually, Commissioner.
What I'm doing.
Commissioner, yes, and that's but in your directive at the end of this, because I think that actually BGE's filing has kind of done that already, and that's why we have this happening now. But to the extent that you believe that there is additional information in terms of what the impacts are or should be, or perhaps there are impacts that have not been fully addressed in the filing, then yes, you would want BGE to file that report in February.
And really, what I was asking was, how did staff view that? Did staff view that this filing made before our order and the reporting requirement actually met that reporting requirement?
I think we viewed this filing as being an adequate explanation of what the impacts of the Tax Act would be. Yes.
And I note that the staff thinks that this filing indicates a reasonable proposal for how to treat these taxes and flow them back to the consumers. How will the recommendation here ensure that we treat every utility who has to file under 88530 the same way? Because I know just in the next filing, the recommendations are different, and we're going to have a bunch of utilities coming in here with these filings, and even though the specific recommendations are going to be apparently different from staff, how does staff make sure we treat every utility the same and not differently?
Well, I think in that sense we're going to be ensuring that everybody gets the same level of review in their filings. The specific outcomes for individual utilities, you're right, they should be as consistent as possible, and we are aiming for that consistency. But there are going to be differences between the circumstances of individual utilities. For example, WGL, in WGL's case, unlike BGE, they didn't have a cost of service study that could be referred back to as a basis for determining how to allocate these things. So there were other things that had to be done. The treatment of the revenue requirement in a last rate case might be very different too. Some of the utilities we are going to see coming in might end up telling the commission that our rates are not explicitly grossed up for taxes, and that's going to merit a different treatment. Some of the utilities, at least one I know of, have not been in for a rate case in a very long time, and it's going to be, again, a different story dealing with them. So we will strive for consistency in our recommendations and our review of these filings, and certainly the Commission is well advised to do the same in its decisions regarding these filings, but that also has to recognize that the individual utilities that we're dealing with are oftentimes very different, and some of them may require different specifics to how this is addressed.
Yeah, so my perspective is from the ratepayer consumer's perspective, not that we treat the utilities all the same, but that we treat all the ratepayers in the state pretty close to the same. They should all have a reasonable expectation of recouping the benefits of these taxes that they've paid, and they have a reasonable expectation to receive them back.
I think that's very well stated, Commissioner. To the extent that a ratepayer is currently paying rates that reflect a 35% corporate income tax, and that rate has now gone down to 21%, you are absolutely right. Every ratepayer in that circumstance deserves to have that situation fixed as quickly as possible.
Yeah, okay, so thank you. I appreciate that explanation, and I would encourage staff to be going forward as we march through all of these filings that are going to come in as a result of our order, treat the ratepayers as consistently as possible, because I think that's what we intended at least partially, when we issued the order. Thank you. Thank you, Mr. Chairman.
Thank you, Commissioner.
Yeah, I just wanted to follow up on Commissioner O'Donnell's. So given that if we do want to have this approach where we treat all of the ratepayers across the state in the same manner, would that, I guess, necessitate that we just come up with one methodology, and that is base the flow through on the class revenue, and not look to other type of alternative distribution methods?
To the extent that that is applicable in a given case, yes, that would be desirable.
But just to make sure that we're doing it exactly the same for all utilities across the state, would you say definitively that then we probably need to pick one allocation method, and again, not try to look to a previous rate case and come up and form that
I
allocation methodology?
I hesitate to say that, Commissioner, because we don't know what we're going to get when we get in the filings from the other utilities, and as I said, the circumstances that pertain to each of the utilities.
Okay, but would it be uniform if we came up with different allocation flow-through methodologies?
Not entirely. I mean,
Okay.
I think we're going to strive to avoid doing that as much as possible, but it's just I think we need the leeway to be able to do it where circumstances may warrant it.
I just also want to ask about the customer charge, and I'm just trying to wrap my head around, inclusion or not inclusion of the customer charge in flowing through. Would there be, I guess, intra-class fairness, usage fairness issues if we did not include the customer charge, or I'd just like to hear your thoughts on that. Again, the equity issue of considering or not considering the customer charge.
Well, I think that's certainly at the back of our minds when we proposed what we proposed in terms of changing the customer charge. Essentially, I think we viewed it as carrying forward on what the commission did in its last rate case and its intent in the last rate case. And so, to be consistent with that intent, you would want to be consistent in your action here, and follow through. If you were to decide differently and decide not to flow any of this through the customer charge, I think you have the right to do that. But in our view, that's less consistent with what you did in the rate case.
Okay, and then as far as just intra-class or just amongst equity, would there be equity amongst the amount of usage of the class, individual members of the class?
I'm having Mr. Hoppeck asking me to give the response to that.
So, Commissioner Richard, I would argue that if you, for example, for the residential class, change the customer charge and the energy distribution charge by the same percentage, on a percentage basis, if you had a customer, with very low usage versus a customer with very high usage, they would see a similar percent decrease in their bill. Whereas if you had a customer charge that remained unchanged and you put all of the change in the distribution charge, the customer who doesn't use very much energy, a larger portion of that bill is that fixed charge. So they would see less on a percentage basis than a customer who uses a lot of energy and would see a bigger change on a percentage basis.
Okay, so for equity reasons, there would be a good argument to try to put some of the flow through on the customer charge. Is that what I heard you say?
Within a class.
Within a class. Okay. And then my last question is just on the recommendations. OPC adds a fourth recommendation, and you're familiar with that? And we'll have OPC up here shortly, but I just wanted to find out what your opinion, what staff opinion is on that recommendation. And basically, it's to order the BG to continue to monitor and track and account for all impacts resulting from the TCJA. So the Commission may order refund and interest of any parts of BG rates the Commission may find unjust in BGE's next rate case.
We think that's actually covered by the Commission's order already.
Okay.
It's also actually covered in our recommendation, which asks to reaffirm that tracking requirement as well, but the Commission's order required that too.
Okay, but you don't explicitly put that in the recommended recommendation.
No, actually, that was direct BGE to establish a liability to account for the tax savings.
Okay, but I think this is in addition to that requirement. OPC both requires the liability and this additional monitoring recommendation.
I don't think we have any objection to that.
No objection to it. Okay, great, thank you.
Anything for staff, Commissioner Linton? Okay. All right, why don't we hear next from the Office of People's Counsel? Good afternoon.
Good afternoon, Mr. Chairman, Commissioners. Mikhail Raker for the Office of People's Counsel. First, we'd like to acknowledge as staff and thank BGE for their proactive approach to this matter, including meeting with our office several times, filing tariff provisions in order to flow the tax savings associated with the Tax Cuts and Jobs Act of 2007 to ratepayers, and expeditiously responding to our data requests. We'd also like to thank staff for their thorough review, and of course we'd like to thank the Commission for its prompt docketing of case number 9473 and the order associated with that matter. It was a quick turnaround to review everything, so in reference to our comments, BGE first notes that there is an agreement between OPC staff and BGE about the amount and timing of the tax savings for reflecting in rates in February 2018. And then to your point, Commissioner Richards, second, BGE expresses concern about our recommendation for it to continue to account for and track all impacts resulting from the Tax Act. And we acknowledge that BGE's response, and just to sort of clarify that point, I think our wording could have been a little bit clearer in that recommendation, but really our intent is simple, and it's to recommend that BGE continue to account for and track all specific impacts of the Tax Act on its revenues and expenses. And although that may be covered by the Commission's order. We just want to recommend that the Commission make that explicit. And we think that that would help parties continue to review the impacts of the tax legislation, and the accounting specifically would provide for a greater ease and transparency for the parties in the next rate case. And third, BGE notes that the Commission doesn't need to act on OPC and staff's request for BGE to establish a regulatory liability to account for tax savings for January 2018 due to the Commission's order in case number 9473. And again, while we acknowledge the Commission's order, in an abundance of caution and for clarity, we'd like the Commission to make sure that BGE does establish that liability and continue to account for January 2018. Fourth, in reference to the allocation of the revenue reduction, as I think pretty thoroughly noted in our comments, we support BG's revenue allocation rate design in its entirety and recommend that the Commission reject staff's alternative recommendations. And finally, we do recommend that the Commission direct BG to file a base rate case no later than by July 1st, 2018. So with that, I'm open for questions.
All right, thank you, Mr. Raker. So OPC's recommending that the Commission not accept staff's recommendation in terms of the allocation, which would reduce savings going to residential customers by a small amount. But the second is to shift some of the savings to the customer charge. So OPC would also not would also oppose that recommendation. Is that correct? And I want to understand why.
Right, and for a couple of reasons, Mr. Chairman. First, I think the office thinks this delves a little too far into rate design as an initial matter, which should be done in a base rate case to more thoroughly examine all impacts. Second, just from a technical standpoint, the office hasn't had an opportunity to fully review all of the numbers and numerical calculations that staff recommend. So if the Commission were inclined to go in that direction, we'd like an opportunity to thoroughly examine all the numbers. And then, as you raised, Mr. Chairman, that might be an issue going forward where the customer charge might decrease and then might increase. And so the result might not be in the best interests of the ratepayer.
Mr. Chairman, I'm sorry. I would like to respond to one point that Mr. Raker just made, and that is that the change in the customer's charge essentially carries through the revenue requirement allocations made in the last, and rate design made in the last rate case. If you don't change the customer charge as staff is recommending, then what you're essentially doing is changing the rate design outcome from the last rate case, and that's what we were trying to avoid.
Okay, thank you. Any questions for OPC? We'll start on this end first.
Yeah, I guess I just, again, on this issue of the customer charge, we just heard staff discuss the potential equity issues between low consumers and high consumers, and without some kind of flow through the customer charge, there would be it would weigh in favor of the higher usage. Does that, as the OPC, representative for the residential consumers, cause any concerns, and that there might be inequity if we don't consider the customer charge in this allocation?
Sure, and we certainly acknowledge the potential for an equity issue, but again, we think that the customer charge issue should be more thoroughly vetted and discussed in the proceeding of a rate-based case than in this matter.
Okay, well, thank you.
Thank you.
Commissioner O'Donnell.
I wanted to ask the OPC, what was the basis for the July 1st recommendation for a base rate case for BGE?
Specifically July 1st, Commissioner. So we'd certainly prefer sooner than later. We proposed July 1st as a date that is a little bit in the future, providing some leeway and time. Your order notes reports from the companies. You're in the tax matter case due by mid-February, so that should create a little bit of lag time and room for other companies and review of those matters, and possibly create some room and some anticipation of that matter moving forward in the commission schedule.
So the list of potential, the initial list of potential grossed up revenue impacted by the tax in our order is 15 plus. So is OPC prepared to recommend and similarly process rate cases for those 15 on an expedited basis, the same way you're recommending for BG&E?
I think we'd have to see each company's analysis and calculations more specifically, but certainly I think we might be in a position to recommend some sort of staggered filing moving forward.
I see. Well,
certainly.
I mean, there may be a case to argue that not waiting too long is a good thing, or conversely, that waiting too long, like 25 years, that a utility may not want to come in for a base rate case is a bad thing, because the customers who paid the taxes probably won't be the customers who receive the benefit of the tax cut when it is reconciled in a base rate case. So I understand that, but I also understand that we can't choke the entire process with a bunch of rate cases. We'll never be able to digest them all. So I just want to get your perspective on that.
And we certainly acknowledge that, and we'll take that into consideration in our next comments. But we think particularly with these utilities, BG I think came in last in November of 2015, would be beneficial to make sure we have up-to-date cost of service studies, as possibly additional benefits from the Tax Act are known and can be passed on.
Thank you.
Thank you.
All right, I think anything else for Commissioner?
I just wanted to clarify that your recommendations 4 and 5, which are directing BGE to establish a regulatory liability and monitoring, tracking all those impacts, in your view, those are, kind of belts and suspenders. Is that right? They're, compared to what we've already ordered in our prior order 88530.
We do, but we just want to make sure that since it wasn't abundantly clear to us, and based on BGE's filings and the timing of the order, what applied when, and so we just wanted to ensure that if the Commission does approve the revised tariff filings, they include these recommendations as well. So yes, Your Honor, sort of belts and suspenders, if you will.
Okay, thank you.
Okay, anything else for Mr. Raker? No, thank you, Mr. Raker. Appreciate it. Why don't we ask BG&E to come up? You can come sit at the table if you like it. It's fine.
Good afternoon, Mr. Chairman, Commissioners. I'm Daniel Gahagan for Baltimore Gas and Electric Company, and I have with me our Chief Financial Officer, David Vahus, as well as the head of our Rates Department, John Frayne. Let me just begin by saying, I've been at BGE now for almost 20 years, and I don't think I've ever had the opportunity to come before the Commission and ask you to reduce rates by over $100 million. So it's a pleasurable experience for me. And as you've heard from the parties, we all agree that the number's correct and that rates should go into effect immediately, tomorrow. There is some rate design discussion that we've heard. But I want to postpone that for a moment and go to some of the specific recommendations around the regulatory liability. So I'm looking now, for example, at the OPC comments, and there's the 5 recommendations. And, with respect to this issue around the regulatory liability, you have already ordered us to establish one for January of 18. We are doing that. Okay, so that has been covered. But they add not only for the tax savings, that regulatory liability for January the one that we propose or that we are establishing relates only to the tax savings going from 35% to 21%. The excess deferred tax portion of the regulatory liability is already there in the existing regulatory liability, so we don't need to create a new one. And let me see if I can make this a little bit more clear. At the end of December, if you assumed, for the sake of argument, that the excess deferred tax balance was $100, in January, we are not amortizing that. It will be there beginning February to amortize, beginning tomorrow, so that customers won't lose any part of that excess deferred balance. So you don't need to add that to this recommendation that staff and OPC made with respect to the regulatory liability. It's covered. Customers will get the full amount of that excess deferred balance over time. So I want that
think
to be
staff
clear.
agrees with you on that now, from what I heard.
Yes, yes.
So there will be no prorating or any effort along those lines?
The full balance will be returned.
Okay, thank you.
With respect to the recommendation by OPC, it's number 5, where it says it's ordering us to continue to track things. Well, you've already ordered us with respect to January to track things. We think we've done all the other tracking in this filing, by the way. We're confident there are no other tax savings out there, that we've captured them here. But with respect to that specific recommendation of OPC, which is not clear to me that it's still being made, they suggest that you would continue to monitor and track the impacts from the Tax Act so that the Commission may order a refund with interest of any parts of BG's rates that the Commission finds to be unjust and unreasonable in the next rate case. And that, we submit, is not a lawful procedure. And so we have no problem with maintaining the regulatory liability you've asked us to establish, but it's not going to be a situation where in the next rate case suddenly we're going to second guess all the rate changes that are occurring today or beginning tomorrow. And we're happy to have continuing discussions with any party. If there's any doubts with respect to our calculations, we've heard no evidence so far if there's any issue with our calculations of the savings that we're passing through. So I wanted that to be clear.
Mr. Gahagan, didn't BG&E itself kind of get your first kind of analysis of this? You got the revenue amount wrong, and then you had to do a subsequent filing. So I think the concern, I know OPC is consulting with the tax attorney. I'm not sure if our staff has yet, but I think their concern is that maybe down the road there'll be something else that you didn't catch and staff didn't catch, and they want to make sure at least that savings is preserved for ratepayers, I guess, going forward.
Mr. Chairman, on that precise point, I think it's our understanding that there may be some fees and charges that that weren't addressed in this filing, and so we have that level of caution as well.
Mr. Gay.
Again, we are confident that we have captured the tax savings. Having said that, we're happy to have continuing discussions, come back to you in another few weeks. If there's a little more time, people want to look at this, we're happy to do that. But we don't wish to leave rates open for indefinite periods of time when others might come in at a future time and create some argument that we didn't have a chance to address until it's too late. And then lastly, with respect to the base rate case filing, I can assure you that BG will be in at some point in time in some form in 2018. But we are trying to manage our costs, and we try not to accelerate the day of that, and we would respectfully request that you leave that to its natural cycle. Are there other questions that you have for us?
Well, sure. I'd like you to respond to two of staff's recommendations. One has to do with including the PL class that is not included in your recommendation. I know you touched on that. But also I want to better understand your reasoning for not including some of the savings in the customer charge part of the residential bill.
If you look at staff's Exhibit 1, which is the first page after its written comments, you'll see a chart at the very top of the page showing the customer charges in effect prior to the last rate case what was established in the last rate case and what is being proposed here. And I think just looking at Schedule R, for example, the residential customers, you can see that staff is proposing a customer charge which is even lower than the charge that was in effect prior to the last case. Now, I think in the last case, there's evidence that shows that the cost associated with serving a customer is in the neighborhood of $15 per customer. That is the actual cost of service for the customer charge. Now, we're not even half of that approximately. So that goes to Commissioner Richards' question around equity. I think one can argue that the low usage customer is already being treated quite well insofar as the customer charge is well below the actual cost of service. And as that chart shows, it's also below, not only what staff is proposing is not only below the cost from the charge that you set in the last case, it's below the charge that was in effect prior to that time. So we think it really doesn't make a lot of sense to change the customer charge.
Okay, and the PL class?
With respect to PL, we did not change that for a number of reasons. One is those customers are on other schedules, so anybody who has private area lighting is also getting a benefit through one of the other schedules, whether it's a commercial customer or a residential customer. Furthermore, with respect to the lighting, there's over 100 lamp rates. So, administratively, it's not impossible. It could be done. Staff has shown they've done that. But when you do that, you're going to have very little impact on the customers in that class. It's in our view, it's better. Those dollars are better left to use to reduce rates for other classes. But this is a judgment the Commission can make.
All right, thank you. Let's go to questions. We'll start with Commissioner Linton, if you have any.
I could ask. Yes. Good afternoon. I had one question regarding BG's response to staff and OPC. It's on page 2. I think you touched on this a little bit in your opening comments regarding the proposal to amortize deferred tax balances beginning in February. I just was wondering if you could explain a little more what you meant by that section.
Sure. So there are two pieces to the tax savings, right? One is associated with the reduction from 35 to 21%. The other piece is associated with the historic excess deferred balances. That excess deferred balance is going to be fully returned to customers just beginning February 1. So there's no need, as staff had originally proposed, to establish a separate regulatory liability for that. It will be captured. It will be returned. So there's no need for the Commission to do that, and I think staff agrees with that now.
Right. Okay. All right. That was it. Thank you. Thank you.
Yeah, I guess not to beat this, but on this customer charge, and I understand and I appreciate the company position overall on why there is a customer charge. But given that we're talking about today, where it's set today, and the fact that we now have this new federal tax reduction, how do we make sure that we equitably return that flow through to all customers? If we don't, as we heard from staff, don't consider today's customer charge and the necessity to reduce it or to flow through to account for that, otherwise there would be this disparity between high and low usages.
Well, again, I think the low usage customer will still get the benefit of the reduced energy charge, the reduced distribution charge. We think they're still being treated quite fairly, more than fairly, in the sense of the overall cost of the customer charge is well in excess of the $750, for example, that is now in place for the residential customers. And I think if you look at the gas customer charge, you'll see that that's significantly higher because the cost to serve a customer is typically in the $15 plus range.
Right, but we're not. Yeah, I think you're answering the question as if we were not talking narrowly and specifically about this brand new federal policy that we're trying to flow through. And if in doing so in an equitable manner, wouldn't we need to look at the current customer charges and set whatever policy going forward with, these flow back based on those and not what the company thinks it should have been to begin with.
Well, Commissioner, I don't agree that the tax law change should affect necessarily the individual components of the rates. I think the Commission has discretion to do that. You obviously have that right, if you wish. I just don't personally believe, the company doesn't believe, that that's the way to make the rate change here.
Okay. All right, I'll appreciate that. Thank you. And by the way, I meant to tell you, I applaud BGE for its proactivity and, putting this right before us today so quickly. And, again, thank you.
Thank you.
For doing that.
Questions for BGE or Commissioner O'Donnell?
Just very briefly, and let me echo my congratulations for coming in right away and not waiting to be ordered to do so. It's appreciated.
Thank you.
So OPC has a concern that we may uncover some other benefit that ratepayers should realize as a result of the tax reduction later, but it's unforeseen now. Staff indicates there may be some fees and other things that may fall into that category, and this commissioner thinks we should kind of make sure that if something does come up later that hasn't received the full financial scrutiny that a rate case would afford this kind of calculation, that we should have the ability and maintain our ability to flow that when discovered or if discovered later back to the taxpayers. Tell me again, I generally understood you don't want to keep rates kind of open or floating forever, but tell me again why we shouldn't maintain our ability to do that.
Well, I think it's just really it's a legal matter. You have a right to change rates prospectively, but you can't just keep going back in time and trying to change rates.
No, but if we find that your calculations were in error, we certainly have the ability to make sure that that error is corrected and reconciled in a way that's fair to all parties. Do we not?
Well, the errors can go.
Your calculation.
The errors can go both ways, right?
Absolutely.
I'm not. If the Commission has reviewed something and made a decision based on accurate information in front of them, which is what we have here, I don't know why you would.
So I'm not asking you a legal question, I'm asking you a policy question. Why shouldn't we maintain our ability to flow those monies back if they're discovered later that they should rightfully be in the pockets of the ratepayers who paid them?
I appreciate that that's what you would want to do.
I know you appreciate it, but tell me again why you don't think we should.
Because I think it's important that when you set a rate, there's some certainty around that we know, companies know and investors know that the revenues that have been authorized will remain to be there, and that it's not a case where there can be second guessing over time as to what the appropriate revenue requirement is.
I appreciate that. I'm just trying to reconcile the two concerns, maintaining the interest of the ratepayers and investors and maintaining the interests of those who paid the bill, or excuse me, the two competing interests of the ratepayers and investors as opposed to the interest going forward of the people who paid the bill originally. So.
Well, we've tried to accommodate customers by coming forward so quickly with this, and we had no obligation to do so.
We certainly appreciate that and have stated so repeatedly, but we need to maintain our ability, I think, to scrutinize this with the full scrutiny it might receive in a base rate case, because it's not getting that now for sure. I don't think anybody maintains it is. It couldn't be in this short a time period. This law was just signed into law a matter of weeks ago, and yet we're dealing with very large sums of money going forward.
Understood.
Thank you.
Just for an example on Commissioner O'Donnell's point, so Mr. Spivak mentioned fees and charges. I don't know what he's referring to, but what if let's say in March, BG&E looked at that and decided, yes, there are some additional savings related to fees and charges from the Federal Tax Reform Act that should go back to customers. How would that happen, absent this?
Well, I can commit to you today that we will come forth with any tax savings that we have not discovered. I do not expect that you will be seeing us on that for that, but I'd be happy to make that commitment today, that if we discover something, we'll come back to you immediately with that knowledge.
And I would say to the extent that there are impacts on surcharges like such as STRIDE or ERI, those are mechanisms that will naturally capture any changes in those costs going forward. And so there's a natural cycle where those changes could be reflected for each of those surcharges. We'll be coming back before you again. We'll be filing in March of this year for a true-up related to the prior year STRIDE costs. That would be an opportunity to reflect any changes in that surcharge as a result of the Tax Reform Act. And so those will naturally be captured as we go forward because that's what those mechanisms are meant to do.
I mean, that highlights the difference between base rates and surcharges, right? A surcharge is an actual cost recovery mechanism by which customers will pay no more and no less than the actual cost. Base rates are different, right? It's a set amount that stays in place until the next rate case. And companies win and lose by that, and customers win and lose by that. It's a different kind of a mechanism. I think you know that we've expressed our opinion that we'd be happy to go to a full surcharge type of formula rate, whereby everything flows through on a contemporaneous basis. But that's not where we are today.
Okay. Unrelated to the item before us, but do you tell us what you think the schedule is for the company filing at FERC or having a proceeding at FERC to return some of the transmission assets related to tax savings back to customers?
Well, that gets very complicated because we have a filing in front of the FERC that has not been acted on yet that would allow some of that to flow through immediately. And we are awaiting some further action by FERC, but I would expect that by June at least, those tax savings will flow through transmission rates.
Commissioner Herb?
Thank you. Good afternoon, Mr. Gehagen.
Good afternoon.
Mr. Gehagen, our order 88530 ordered that all companies, shortening some of it, are directed to track the impacts beginning January 1st, 2018 and apply regulatory accounting treatment, which includes the use of regulatory assets and regulatory liabilities for all impacts resulting from the Tax Cuts and Jobs Act of 2017, right?
Yes.
So I assume then you're not objecting to the language, for example, that OPC has about the tracking, but is it your objection that the refund, is that your portion of the, is that where your objection lies?
That's correct. That's correct.
Okay, so you are interpreting that as a continuing obligation to continue to track, is that right? Because I thought you said that you had, I just wanted to be clear, are you done tracking and this is the result of that filing, or are you going to continue to track?
I'll let maybe Mr. Vajas address that more specifically, but certainly for the January 2018 period, that will be tracked very closely. Do you want to?
Yeah, good afternoon, everyone. Thanks for having us here today. So, I don't anticipate, as Mr. Gehagen expressed, any other benefits from the Tax Reform Act being discovered based on our review, both with internal tax experts and external tax experts and across the industry. But I echo Mr. Gehagen's commitment to this commission that should something come to light that we missed along the way, we will be here and we will tell you about it and we will move forward with that item. But again, I don't anticipate that. So in my mind, I think we have satisfied the requirements, both with the regulatory liability we're going to establish for January with respect to the reduction from 35 to 21, as well as the change in the rate starting February 1st.
Okay, so that in the company's, it's the company's position that it has satisfied that and then made the filing as well, satisfied both elements of that.
Yes, Your Honor.
Okay, thank you.
Follow up. So I appreciate the offer of both of you that should you discover something down the road that should have been brought to our attention, you'd be back in here. I appreciate that. Are you under a legal obligation to do that, or you would just do that as a good corporate
You
citizen?
could order us to do that, and it would be a legal obligation.
I know we could, but I'm asking you what your
I don't know
intention
that
was
there's
when you said it.
necessarily one. I don't know. I'd have to think about that.
Okay. So you wouldn't have a problem if we ordered you?
I would not have a problem with that.
Very good. Fair enough. Thank you.
anything else? Any other questions from BG&E? Okay, if not, let me express my thanks as well for BG&E being so proactive in getting this filing before us to get savings back to customers as quickly as possible.
Thank you.
Much appreciated. Well, let me, as I always do, check with staff to see if they have anything to add.
No, Your Honor. Actually, I think we've said what we needed to say.
Mr. Gahagan, I think the Commission is going to take this under advisement, but our goal will be to issue something later this afternoon. So I wanted to get a sense of your time frame in terms of being able to implement these rates by July the 1st.
Yeah, we are under a big time constraint in terms of implementing these rates. We need to get them in by 6 p.m. tonight in order for them to be ready for bills. And so as soon as the Commission could issue an order, we would appreciate it.
Okay, so if the Commission were to issue an order by 5 o'clock, is that enough time? Or is it cutting it close?
I don't believe that would be enough time. I think we would need an order, earlier this afternoon in order to be able to put those rates into our billing system. There's a lot of checks and controls, as you can probably imagine.
Envisioning the scene from the movie The Post that I just saw.
Yeah.
Where you're standing by the phone. So give me a time.
If it could be by 3 p.m., that would be helpful.
Okay. All right, we'll try to do it by 3. I understand that. I appreciate you working with us on that. There are a few items I think we need to think through, which we'll probably need to consult with our attorneys on before we do it. So we'll try to do it as close to 3 as we can. All right.
Thank you.
All right. Thank you.
Thank you.
Appreciate it, gentlemen. Thank you. All right, let's go to our last item.
Thank you, Commissioner.
Mr. Chairman, last item on the agenda, it's Washington Gas Light Company filed revised tariff pages, and again, the company proposes to revise its distribution rates, also to reflect the impact of the Tax Cuts and Jobs Act of 2017.
Good afternoon, Chairman, Commissioners. Janice Flynn for this final item on our agenda. WGL has filed revised tariff pages to lower distribution service rates for Maryland customers to reflect the impact of the reduction of federal income taxes on corporations from 35 to 21%. WGL revised its initial January 12th filing on January 23rd to include additional rate reductions resulting from the inclusion of gross receipts tax and PSC assessments in the company's tax gross-up factor. The revised filing also included a calculation of the effect of the new federal tax rate on the amortization of the company's net operating loss carryforward to include the 2016 tax return true-up adjustment. This adjustment lowered the total NOLC, and as revised, the tariff revisions are intended to flow $14.8 million in tax savings to ratepayers. The average Maryland residential customer will experience a decrease of $2.16 under the company's filing. The total tax savings consist of primarily 2 components, and we've discussed this with the BGE matter. The first is the income tax rate produces a decrease of $10.2 million in the revenue requirement based on operating revenues and adjustments from BGE's last rate case, which was 2013, case number 9322. And the next component is a $4.7 million in refund resulting from adjustments made to the excess accumulated deferred income taxes. Staff has reviewed WGL's calculations and finds that they are reasonable. Staff has also reviewed OPC's comments regarding the filing. Staff does not agree with the comment that gross receipts taxes have not been fully taken into account. Staff has reviewed the calculations and concluded that WGL's revised filing properly accounts for these gross receipts tax. In addition, with regard to uncollectibles, because uncollectibles are not part of WGL's conversion factor, it is not necessary to adjust this item at this time. With regard to the amortization period of the NOL carryforward, staff believes the 15-year period chosen by the company is reasonable and is correctly based on the estimates of the company's tax liability going forward rather than over the 34-year period based on the depreciable lives of underlying plant-related assets. As discussed in the BGE matter, staff does not recommend that the Commission order the company to file a rate case by a date certain. The company has stated its plans to file in the first half of 2018. Staff has also reviewed the WGL allocation of the income tax savings. WGL allocated the revenues and rate structures under the 9322 rate case, and staff has reviewed those allocations and finds that method to be reasonable. Staff also determined as appropriate to apply the entire reduction to the distribution charge, since no increase was ordered to the customer charge in the last rate case. WGL notified staff yesterday that it can implement these tariff revisions tomorrow, and thus it requests that the tariff be approved effective February the 1st, and this is a change from our written comments. To that update. Staff's recommendation, therefore, is this, that the Commission waive the 30-day notice requirement of Section 4-203 to allow implementation of the rates effective February the 1st, accept the company's proposed rates for filing, direct WGL to establish a regulatory liability to account for tax savings for January 2018 for changes in operating income, with the inclusion of return component to be examined in WGL's next rate case.
All right, thank you, Ms. Flynn. Any questions for Commissioner Herman?
Ms. Flynn, I'm having a little trouble understanding the difference, on the customer charge. And the reason is because they didn't increase the customer charge in the last rate case. So, okay, I understand there's a distinction between an increase and not an increase, but why does that matter? I think what we did was try to follow the rate structure from the last rate case. And I'll let Ms. Ward speak to more specifically why it is that this is being treated differently than the BG case.
Jennifer Ward, behalf of staff. It is the same as BG, where we only assign the decrease to any class that was assigned an increase in the customer charge previously. So in WGL's last rate case, no customer class received a customer charge increase, and so we only applied it to the distribution charges.
Okay, yeah, I understand the methodology. I'm just not sure I understand the rationale.
Commissioner, Juan Alvarado on behalf of staff. I think that just as an overarching philosophy, we thought that our goal was to take out the money the way it went in. And in doing so, ensure that the rate design and the allocations that the Commission approved in the last base rate case remained the same. And that's very much like the way we treat medical proceedings for small gas companies and things like that, in which we ensure that everything else remains equal. All we were doing is trying to pull out the money. Not personally, I'm not sure that I feel super strongly about this customer charge discussion. What you need to understand when you make the decision is the following: if you don't apply this to the customer charge, what you're going to be doing is you're going to be changing the rate design that you approved in the last base rate case. You're going to be changing the way the rates interact with each other. Presumably, when the Commission in a rate case decides what the customer charge should be, they look at the level of the customer charge and they look at the level of the variable rate, and they decide how those should interact. If you change one but don't change the other, then that interaction changes. And our goal was to make sure that it doesn't. Of course, you could also argue that if you want to keep the customer charges at the level they are and change that interaction, but your goal is to keep the customer charges at the level they are, then you shouldn't do that. But our goal was to make sure that everything remains exactly the same as it was after the last base rate case.
Okay, thank you.
Anything else for staff? Commissioner O'Donnell.
So with the last case, it was easy because they're implementing the rates tomorrow, February 1st. In this case, the company proposes to implement them February 5th.
Oh, Your Honor, sorry to interrupt, but they have now committed that they can implement these tomorrow, February 1st.
Very good. then never mind.
Anything else for our staff?
Yeah, I'll just ask the question again, if I may, Mr. Chairman, about, again, the intra-class, equity with the customer charge, considering that the full bill is based on volumetric and the customer charge. Again, I understand that it would change from the last, allocation, but wouldn't there be an equity issue? And also just based on what your colleagues in the previous panel stated?
Let me turn this back over to Mr. Alvarado.
Commissioner, presumably when the commission made a determination as to the level of the customer charge versus value charge in the last rate case, you made a determination as to what would be equitable to low-income customers versus non-low-income customers, or versus high usage versus low usage, all these different types of customers. If you want to keep that consistent, and what you want to do is apply this to the customer charge as well, because otherwise, the level of the customer bill, the way a person receives a bill based on their usage is going to change. And so, if you want to keep whatever determination you made, and again, my job is not to say whether that's the appropriate one or not. You made that decision, and we live by that. If you want to keep that consistently, then you want to make the change to the customer charge as well. Now, in this case, it's very simple because there were no changes to the customer charge in the last base rate case. So we don't have to worry about it. But in BGE, particularly for the electric, there was a change to the customer charge. And so if you want to keep everything consistent with your decision, you need to make that change to the customer charge. Otherwise, things will change. And that's what we're trying to send through to you, that's a consideration you need to make when you make this decision.
Okay, appreciate the answer. Thank you.
All right, anything else for staff? Okay, now let's hear from OPC, if you'd like to be heard, and then the company.
Thank you again, Mr. Chairman and Commissioners. Mikhail Raker on behalf of OPC. Good afternoon. And again, as with BGE, we'd like to thank WGL as well for their proactive approach and expeditious responses to discovery, and to staff for their thorough analysis and review. As we note in our letter, and I think one of the most important disagreements here is that we don't believe that WGL has properly accounted for the impact of the Tax Act on its operating income. We do acknowledge that they did file a revision, but based on conversations with our consultant, we still believe that there are errors in that calculation, and we note those in our comments, and therefore request that the company refile revised tariffs. And as in my previous statement about our comments as to BGE, we'd also like to clarify our request for WGL's continued tracking and accounting of the impacts. And again, as with my comment previously, our wording could have been a little bit clearer, but we do want to just request that the company continue to specifically track and account for the impacts of the Tax Act, and so that then those can be reviewed in the next base rate case to provide more clarity and ease for all parties. So I think with that, we would also like to, again, recommend that WGL be required to come in no later than July 1st, 2018 for its base rate case. And I think there was some discussion previously between the Commission and BGE that might also sort of substantiate that point, that there may certainly be other things that come to light. And I think the intense scrutiny of a base rate case proceeding may certainly shed some more light on the impacts of the Tax Act. So with that, I'm open for questions.
All right, thank you, Mr. Rick. Any questions for?
Maybe just on your point about the gross receipts tax issue, if we were to adopt your proposal, recommendation that we require WGL to continue to monitor and account for all impacts, could that, in the interest of expeditiously trying to get this rate relief to the customers, would we be able to handle that potential issue? If your position was confirmed at a later date?
I think certainly conceivably if the liability was created and that was tracked, that could certainly be handled in the next case, just in terms of expeditiousness, in terms of thoroughness. We commented and would like the company to, and as we note, this would be the same approach that BGE took to implement this in their current numbers, but certainly this could be something that's tracked and brought out later as well.
Okay, because if we take your recommendation to require refiling, the customers will have to wait some period of time before they begin to enjoy this federal new tax policy.
And we acknowledge that and bring that matter to your attention. I think in terms of the overall difference, it's not certainly huge, but we did want to bring this to your attention for thoroughness and for the sake of accuracy, and certainly that can be weighed against the expeditiousness of getting savings back to customers.
Okay, great, and I do appreciate the thoroughness and you bringing this to at least my attention and to the Commission. Thank you.
Thank you.
Anything else for OPC? Thank you, Mr. Raker. Okay, let's
Thank you,
bring
Mr.
the
Chairman.
company up.
Good afternoon.
Good afternoon.
Commissioners. John Dodge appearing once again on behalf of Washington Gas. To my left is Jim Wagner, our Director of Rates and Regulatory Affairs. To his left is Robert Turnimi, our Chief Regulatory Accountant. I'm definitely deferring to these gentlemen today for the technical answers that I'm sure you may have questions for. I did want to raise one issue about the magic language we think we need to put our rates into effect tomorrow. Staff counsel referenced this. Our filing said, I want to make sure I get the proper language. We proposed the language in our effective line on any page of our sample tariffs, effective for services rendered, and then we provided the date of February 5th. As you now know, we believe we can implement these rates starting tomorrow, but we prefer that the effective language read for bills rendered on or after February 1st. We gave ourselves a little running room in our prior filings. We have used our new SAP system to run test bills, print out test bills in a parallel environment. I did not know we could do that, but apparently we can, and we're confident that we can start issuing bills with the lower rates tomorrow. But again, we'd like the effective language to read for bills rendered on and after February 1st, 2018. With that, at a very high level, we disagree with the points that OPC has made. We do appreciate their alacrity in getting back to us with their comments and their questions. I wish all cases could be processed in a 10-day time frame. That would be great, and we worked very well with OPC and staff in that regard. We do think that our revised filing meets the requirements for the February 15th report implicated in Order 88-530. Let me see everything else. We are willing to track, of course, any additional savings from both January or that come up in further investigations and report those back to the Commission. We have shared with the Commission in the past in both case 9335, our Stride case, and in 9449, our merger case, that the company has plans roughly to come in the May to June time frame for our next base rate case. We would prefer, like BGE and I suspect every other utility in the state, not to be directed to file by date certain, but you have our assurance that we are very likely to come before you for our next base rate case before July 1st in any event. With that, I'd like to open it up for your questions, unless my colleagues have high-level comments to begin with, and we're here to answer all your questions.
Thank you. Any high-level comments?
This is Robert Turinimi. I just had one point. In reviewing staff's testimony, the company does take exception to the requirement after we track the cost, to include a carrying cost on that. to clarify the record, the staff puts a number in, and our review of that number is they took the total expense for the year, the reduction for the year, and divided it by 12. As Mr. Dodge said earlier, we're implementing these rates for bills rendered starting tomorrow. That means that nearly half of the bills that go out will have January usage in it, so staff's recommendation is probably 50% higher than the magnitude of those dollars. The other point that I wanted to make on that is that the company's not getting any cash flow benefit as a result of the tax reduction. We're currently in a net operating loss position. There's no cash going out the door. There will be no cash coming in the door for a reduction in rates. And so to accrue a carrying cost at a pre-tax cost of capital to us doesn't make sense. It's not reflecting the cash flow implications of that. So we do take exception to the carrying cost component of that. But we are tracking those costs, and we'll have those recorded in the regulatory liability going forward.
All right, thank you. Questions for WGL? Start on this side. Start with Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask, just to clarify on the language for bills rendered on or after February 1st, 2018, you don't need that same language for the waiver, the 30-day notice requirement waiver, do you?
No, I don't believe the statute requires that.
Okay, so the for meter readings on or after February 1st, 2018 would be sufficient for that waiver.
I need a chance to think that through.
I think, well, that's the original proposed recommendation of staff, was for the 30-day waiver would be for meter readings. I didn't know if there was a difference between that and the...
I'm sorry, that really doesn't need to be in there, that language. I'm sorry, that's confusing. That the 30 days is not tied to the effective date of this.
Okay. I'm just reading off the recommendation.
I understand.
Okay. Very good. And the discussion I had with BG&E regarding whether or not somewhere down the road something was discovered and we all say, oops, we missed that, that should flow through to the customers as an impact of the tax change. Would you have any problem if we put an ordering provision, should you discover such an anomaly going forward, that you come back with that?
Yeah, Commissioner O'Donnell, my answer would be no, that in the coming rate case this year, all parties in the rate case will have the ability to look at what occurred as a result of the tax change. So as Mr. Tormini mentioned, whether a return should or shouldn't be included, that'll be something that in the rate case, with testimony, with hearings, with briefs, all of those issues can come out to arrive at the correct answer.
Thank you.
Any Commissioner Herman?
I guess I'm a little confused because OPC, whose comments are dated the 29th, seems to continue to have a problem with your calculations on the gross receipts tax. So I see that you filed a revised version that you say updated that for gross receipts tax. So where's the misunderstanding?
I will start, and I'm sure Mr. Tornimi will finish out. In our first filing, we simply omitted the gross receipts tax implication. So the January 23rd filing was to include importation of the gross receipts tax. OPC, as I understand Mr. Raker's comment, still disagrees with how we calculated what we put in on January 23rd. I will not pretend to understand the nuances of that. Mr. Tornimi may be able to speak to that. Staff and we think we did it right. This is one of those issues that perhaps could be resolved or further discussed, at least in the context of the rate case, that all parties would reserve their rights to bring up matters like this in the rate case. I would note that it's real money, but it's I believe between $100,000 and $200,000. So the loss to a customer, a residential customer, probably would be a penny or less per month per bill. So I don't think we're talking of a magnitude that should slow down imposition of the new rates.
I'd like to clarify that a little bit. My understanding is that OPZ's position is not on the gross receipts tax, but on the uncollectible accounts rate. I think staff and we and OPC, and they can speak for themselves, are now in agreement on gross receipts tax.
Okay.
The issue is on the uncollectible accounts rate. Staff and Washington Gas agree on that, and OPC does not, and that is the $100,000 number that Mr. Dodge was quoting.
Okay.
And that is uncollectible, of course, is an element of cost of service and could be treated in the next rate case. We might point out that the company hasn't been realizing its authorized level of disconnection of service revenues, but that starts away from focusing on getting tax relief back to people as quickly as possible and start sounding more like a rate case.
Okay, thank you.
Just for a quick clarification, Your Honor, we do believe there's still a disagreement between the gross receipt taxes and the uncollectible accounts. In
Okay.
terms of our stance on the matter.
Okay, thank you.
And just one additional comment, Commissioner Richard, certainly the implementation could go forward, but also there could be a recommendation that the parties convene to discuss this specific matter that we believe could require attention, and then maybe a new filing after that as well. So that could be an additional way of moving forward.
If it would help the commission, the company will commit to that meeting so as not to delay an order approving today's rates.
Thank you. Any more questions for the company?
Mr. Chairman, no questions. I just want to also thank WGL for your alacrity, I like that word, and also proactivity in filing this case.
My daughter recently, she's a high school senior and took the ACT, so I'm sure that word was where I got that.
Anything? All right, and let me express my thanks too to WGL for getting your filing to us so quickly so we can get these savings back to customers quickly. Much appreciated. I'm not going to ask you when you need this order by because we can't do it any sooner than 3 o'clock. So, but the same applies to you. We're going to take this under advisement and try to get an order out very shortly. So thank you.
Thank you, Your Honors.
All right, very good. Before we, and thank staff again for their presentation. Before we adjourn, I need to bring up for anyone in the room who is here for the pre-hearing conference, and I see Mr. McKeel is here, for PEPCO, that I think the Commission would like to postpone that until 3 o'clock. I know staff in OPC work in this building. Hopefully that's not going to be an issue for our staff in OPC, but let me check with Mr. McKeel and see if that's doable. Okay, very good. Any other concerns from AOBA or any other party in the case about meeting at 3? All right, very good. Then we will adjourn, and we will be back at 3 o'clock for our pre-hearing conference. Thanks, everyone.